This is a 126-page judgment. I asked the Chief Justice whether I should read the entire judgment. He said, please no. And so I'm just reading a few selected passages. All right. On the perception of the capability of drivers on the road, the comedian George Carlin made the humorous observation to the effect, have you ever noticed that anybody driving slower than you is an idiot, and anyone going faster than you is a maniac? Concerns about road safety are often shaped by individual biases without the opinion being founded on any empirical data. It is easy to overlook the full spectrum of factors that contribute to road safety. In this context, the pivotal legal issue that this constitution bench of 5 judges has to decide is whether, under the existing legal framework of the Motor Vehicles Act and the Central Motor Vehicle Rules, a person holding a license for a light motor vehicle class can drive a transport vehicle without a specific endorsement, provided the gross vehicle weight of the vehicle does not exceed 7,500 kgs. Besides road safety, the livelihood concern of a large number of drivers of transport vehicle in India also requires an answer from the bench. In this judgment, let us name our driver Sri, who is a transport vehicle driver. As can be appreciated, Sri spends maximum hours behind the driving wheels and is arguably the most experienced one amongst the Indian drivers, carrying goods and people from destination A to B and so on. It is true that Mukund Devangan did not analyze the provisions that distinguish transport and non-transport vehicles, as noted in the reference orders. The statutory scheme of MV motor vehicle is more nuanced than the simple weight-based distinction made in the said judgment. Moreover, the court failed to notice section 31.2 and 31.3, which specifies transport and non-transport vehicles. However, the judgment gave due consideration to the important statutory provisions. We have carefully looked at the relevant and the wide-ranging provisions in our analysis in this decision. A harmonious interpretation, as we have explained earlier, would lead us to the same conclusion, but fortified with some additional reasoning based on the consideration of all the relevant provisions. The overlooked provisions would not, in our considered opinion, alter the eventual pronouncement. Importantly, we do not notice any glaring error or omission that would alter the outcome of the case. Road safety is a serious public issue globally. It is crucial to mention that in India, over 1.7 lakh persons were killed in road accidents in 2023. The cause of such accidents are diverse, and the assumption that they stem from drivers operating light transport vehicle with an LMV license are unsubstantiated. Factors contributing to road accidents include careless driving, speeding, poor road design, and failure to adhere to traffic laws. Other significant contributions are mobile phone usage, fatigue, and non-compliance with seatbelt or helmet regulations. Driving a motor vehicle is a complex task requiring both practical skills and theoretical knowledge. Safe driving involves not only technical vehicle control, but also proficiency in various road conditions, including managing speed, turns, spatial awareness relative to other vehicles. Additionally, handling road gradients demands skill, particularly with brakes and maneuvering. Effective driving requires awareness of road signs, adherence to traffic rules, and a focus on the road free from distraction. The core skills expected of all drivers apply universally, regardless of whether the vehicle falls into transport or non-transport category. As discussed earlier in this judgment, the definition of LMV under Section 221 of the Motor Vehicle Act explicitly provides what a transport vehicle means. This court must ensure that neither provisions, i.e. the definition under Section 221 or the second part of Section 3.1, which concerns the necessity for a driving license for a transport vehicle, is reduced to a dead letter of law. Therefore, the emphasis on transport vehicle in the licensing scheme has to be understood only in the context of medium and heavy vehicles. This harmonious reading also aligns with the objective of the 1994 amendment in section 10(2) to simplify the licensing procedure. The above interpretation also does not defeat the broader twin objective of the Motor Vehicles Act, road safety and ensuring timely compensation and relief for victims of road accident. The aspect of road safety is earlier discussed at length. An authority pronouncement by this court would prevent insurance company from taking a technical plea to defeat a legitimate claim for compensation involving an insured vehicle weighing below 7,500 kgs driven by a person holding a driving license of a light motor vehicle class. In an era where autonomous or driverless vehicles are no longer tales of science fiction and app-based passenger platforms are a modern reality, the licensing regime cannot remain static. The amendments that have been carried out by the Indian legislature may not have dealt with all the possible concerns. As we are informed by the learned Attorney General that a legislative exercise is underway, we hope that a comprehensive amendment to address the statutory lacunas will be made with necessary corrective measures. Then we have to flag one concern. The legislature, through the 1994 amendment in section 10(2)(e), in order to introduce transport vehicle as a separate class, would not have intended to merge light motor vehicle, which continued as a distinct class, along with medium and heavy vehicles into a single class. Else, it would have given rise to a situation in which Sri, our hypothetical character, wanting to participate in a cycling event, is put through the rigorous training relevant only for multi-sports like triathlon, which requires a much higher degree of endurance and athleticism. The efforts, therefore, should be to ensure that the statute remains practical and workable. Now, harking back to the primary issue and noticing that the core driving skills, as enunciated in the earlier paragraphs, expected to be mastered by all drivers are universal, regardless of whether the vehicle falls into the transport or non-transport category. It is the considered opinion of this court that if gross vehicle weight is within 7,500 kgs, the quintessential common man's driver Sri with LMV license can also drive a transport vehicle. We are able to reach such a conclusion as none of the parties in this case has produced any empirical data to demonstrate that LMV driving license holders driving a transport vehicle is a significant cause for road accidents in India. The additional eligibility criteria as specified in the Motor Vehicles Act and the rules as discussed in this judgment will apply only to such vehicle: medium goods vehicle, medium passenger vehicle, heavy goods vehicle, and heavy passenger vehicle whose gross weight exceeds 7,500 kgs. Our present interpretation on how the licensing regime is to operate for drivers under the statutory scheme is unlikely to compromise the road safety concerns. This will also effectively address the livelihood issues for drivers operating transport vehicles who clock maximum hours behind the wheels in legally operating transport vehicles below 7,500 kg with their LMV driving license. Perforce, Sri must drive responsibly and should have no occasion to be called either a maniac or an idiot, as mentioned in the first paragraph, while he is behind the wheels. Such harmonious interpretation will substantially address the vexed question of law before this court. Our conclusion following the above discussion are as under: a driver holding a license for light motor vehicle class under section 10(2)(d) for vehicles with gross vehicle weight under 7,500 kg is permitted to operate a transport vehicle without needing additional authorization under section 10(2)(e) of the MV Act, specifically for transport vehicle class. For licensing purpose, LMVs and transport vehicles are not entirely separate classes. An overlap exists between the two. The special eligibility requirement will, however, continue to apply for inter alia, e-carts, e-rickshaws, and vehicles carrying hazardous goods. The second part of section 3(1), which emphasizes the necessity of a specific requirement to drive transport vehicle, does not supersede the definition of LMV provided in section 221 of the Motor Vehicles Act. The additional eligibility criteria specified in the MV Act and the MV rules generally for driving transport vehicles would apply only to those intending to operate vehicles with gross vehicle weight exceeding 7,500 kgs i.e. medium goods vehicle, medium passenger vehicle, heavy goods vehicle, and heavy passenger vehicles. The decision in Mukund Devangan is upheld, but for reasons as explained by us in this judgment. In the absence of any obtrusive omission, the decision is not per incurium, even if certain provisions of the MB Act and MB rules were not considered in the said judgment. The reference is answered in the above terms. The registry is directed to list the matters before the appropriate bench after obtaining direction from the Honorable Chief Justice.
Obliged, deeply obliged.
Hello, sir. May I know the matter number which you are mentioning?
I am opposing a mentioning by Mr. Khosla. So I'm watching that.
Mr. Khosla. Okay, sir.
The first row.
Okay.
Sir, I'm mentioning an unlisted mentioning. We did send an email, but we were unable to get it.
Sir, may I know the matter number, sir? Any diary number or any SLP number, sir?
It's it's Sukanya Shanta writ petition.
Sir, I know that. I want to know the
1404
number.
of 2023. 2023.
It's writ petition, sir. 1404 of 23.
Okay, that's right.
Thank you. Okay.
Oh, okay. I
Yes,
just
sir.
wanted to give the diary number of that MA that I'm mentioning. It's
Yes, sir.
55110 of 2024.
5110 of 2024.
That's the diary number for the MA.
Right, sir. Sure, sir.
Okay.
Fine. Thank
Okay.
you.
Right.
Yes, solicitor.
May I have my lord's permission, my lord? I'm sorry for the indulgence. My lord, there is one we have filed in a suo motu petition. My lord, if your lordships can just have a look at it, my lord, and list it, my lord, on some day.
All right.
But there is one more matter filed by CBSC, Central Board of Secondary Education. That, my lord, it is shown on 18th, may not be deleted. There is some urgency.
Lordships, I wanted to mention
Yes, Akija.
the vulnerable witnesses matter, your lordships. There's a direction.
Yes, Geeta Mittal is
Yes.
chairing the committee.
There's one direction that is required with regard to the new BNS being incorporated in the guidelines. If your lordships would be kind enough to list it tomorrow, we can do that.
Is there a report by Justice Geeta
Yes,
Mittal?
your lordships, it's there.
Place it if possible first report so that we can relieve
Yes.
the formal form.
Very grateful, very grateful.
If just keep if the report
I'll
doesn't
keep it
come
in
here,
mind.
just keep a separate copy so
I'll
we'll
do that.
pass an order and
Very
just immediately.
May I
Very
seek the court's leave to mention?
Sir, if you can just send an email, tell your junior to send an email to the court master.
I'll do that.
We'll make sure it's circulated to us in the soft form.
I'll do it immediately, your lordship. Grateful.
With my lord's kind leave.
Yeah, yes, Dr. Muralidhar.
In the Sukanya Shanta matter, we have filed an MA for a clarification regarding one of the directions on the deletion of mention of caste in the registers. We had actually sought to send an email, but they said since it is a disposed of writ petition, that procedure is not available for MAs.
Kind of caste-wise data collection of prisoners by the NCRB.
Yes,
Where
yes.
have we injuncted NCRB?
No, we just therefore want, because what is happening is some of them are quickly implementing this, unmindful of that direction. That's why.
All right. We'll keep it tomorrow.
I'm obliged.
That Great Indian Bustard matter, it was listed yesterday. It didn't come up. Whenever it's convenient, your lordship may have it.
Critical rather. That had to, because we had a heavy board.
I understand.
The report has also come. I saw
Yes.
the report.
Yes.
So we have to now just pass final orders.
Please.
My lord, I'm seeking liberty to make a mention, my lord, that may not perhaps fit in.
What you are paying for the Union of India? Or
For the solar power deal.
whatever. We have to look at the report now. Yes.
Lord,
Yes.
the mention that I wish to make, my lord, pertains to a matter that was heard by your lordships this very bench in February 2024. And the opportunity presented itself to your lordship's bench to settle a very vexing question of law under the IBC. And after getting a rough hearing, both parties agreed for a consent order, leaving the question of law open, even though an issue had been settled by another coordinate bench and 3 judges bench in the matter.
Resolved by consent before us.
Yes, my lord.
Then?
So, my lord, so we are similarly placed as the, if I may say, my lord, perhaps collusive petitioner in that matter, which is a state actor.
Now I don't
Lord,
think we'll have time in the next two.
My lord, let it be at the end of your lordship's board, my lord. The matter will not.
Well, I have to say
Section
something,
11
your lordship.
petition,
Well,
what
I have
is
to
he
say in
saying?
this matter.
My lord,
He's not
your lordship.
giving facts.
In this matter, Malad.
To the arbitration.
Oh, wait, they are strangers.
Please,
not a
my
party.
Anyway, we don't have
Lord,
time.
Lord,
The
with due
matter
respect,
is
Lord, with due respect,
You have filed
versus
an MA.
Arsenal.
Just give me 1 second. You have filed an MA.
my lord, just allow me.
What have you filed?
An MA, my lord, just allow me
It
30
will be
seconds.
processed by the registry.
Lord,
Lord.
he's not even.
He's
he's
not a party, it's an arbitration
So the
reference, it's
party
nothing to do with the
protesting and
matter.
getting a better
Nothing whatsoever.
opportunity than the party requesting.
Lordship, if I
Lord, may I just finish what I want to say?
All right, tell us what. We'll hear. Just give us more.
Lord, ArcelorMittal is a very heavy electoral bonds contributor.
Yes.
The matter involves 66,000 crores of public money, whose payment has been suppressed since 2019 by prevailing upon collusively acting state actors. The state actor in this case was the Indian Oil
Tell
Corporation.
us one thing. Who are you first? Tell us.
I am similarly
Well,
placed to Indian Oil
It's a
Corporation.
section 11 between Indian
Dr.
Corporation
just
and
1
me.
second. Let him have his day in court.
My lords,
Who are you first? Tell
I
us.
am also a 1 rupee claimant who did not get paid because my claim was under a moratorium similar to Indian Oil Corporation.
Right. Now, what was the matter before us? Because frankly, we don't even
Yes.
recall what the thing
What
is
is-
all
Can I
about.
explain, Malad?
There was Section 11.
Dr. Singh, let him have. The learning council should have the satisfaction of having
Very
this
well, very
told
well,
us
very
what
well.
is-
Very
My
well.
lord, there was a Section 11 filed by IOC in Delhi High Court, dismissed by Delhi High Court,
Right.
on the grounds of a spurious argument raised by ArcelorMittal that because the claims of IOC were notionally quantified at 1 rupee in the plan, whereas the claim was for 4,000 crores, therefore there is no liability of the SRA to meet that payment. On this premise, IOC came in appeal before your lordships in SLP.
Right.
Your Lordships heard the matter on 5th of February.
Now, IOC had filed a section 11 before the
IOC
Delhi High.
filed a section.
My lord, if I may finish, my lord, they want to take over.
section 11 by IOCL was dismissed by the Delhi High Court.
Yes, my lord.
They came here.
Yes, my lord.
Then what order did we pass?
So, your Lordships, there was a very rough hearing on 5th of February insofar as ArcelorMittal and judgment was reserved. Allow me to finish, my lord. Realizing the implication of reserving of judgment not just on this 4,000 crores but on the remaining 66,000 crores, IOC was prevailed upon to appear before your Lordships to agree to a consent.
Consent to what?
Malas, can I just say something,
We'll
Malas?
try to take
Can
over
I
the
say
hearing.
something for a minute, Malas?
The consent, my lords.
Your
What happened?
Then, my lords, a consent was arrived at whereby I have no difficulty with the consent.
Right.
My difficulty is that your Lordships granted liberty, keeping all rights open, including the question of arbitrability. Now, if the question of arbitrability will include various...
Now, by consent, we allowed parties to go to arbitration, right?
Correct.
Now, that was, who are the parties? IOCL on one side and
ArcelorMittal
on the other.
Yes, my lord. Now, my lord,
Can I say something?
Now, give me 1 second. We'll just, he's got lots of difficulties in his way. Therefore, we allowed parties to go to arbitration, recorded it as a consent, and they went to arbitration.
Correct. Now, your lordship.
Now, tell us, who are you?
My lord, I am similarly placed to IOC. I am also a 1 rupee claimant. No. If I may just finish my next sentence.
You pursue your claims in accordance with law. Why should we hear you here?
My lord, if I may just finish my sentence.
But you have an MA. You have an MA in a disposed of matter.
My lord,
just 1 second. We can't hear you till 4 o'clock merely because we are here till 4 o'clock. Whatever you have filed an MA, standard directions to the registry, they'll process the MA in accordance with law. That's all.
My lord,
we are not passing any order today on this. Let the registrar deal with the MA in accordance with law. That's
just
all.
finish my
Well, apart from it being an MA in a disposed of matter, it
Lord,
was a section 11 by
I'll
IOC
just finish
and
my
High
sentence
Court.
and I'm done.
We succeeded.
I am not aggrieved by the consent order. I am aggrieved by the ramifications of the widest amplitude that your lordships recorded in that consent order, that all rights and contention left open, including arbitrability. I only want your lordships to say
all issues to be left open.
No. I have no difficulty with all issues.
Inter partes.
Well, not just allow me.
Just 1 second. That's right. Now we'll close and put an end to this.
I just finish my sentence, my lord. I'll just finish my sentence, my lord.
Just 1 second.
Kindly pass no order,
arbitration. If one of the parties has some difficulty about, doubt about, they always say, just keep my remedies under section 16 open. So
I'll just finish my sentence, my lord, that I'm done.
Yes.
All I'm seeking is that your lordship may clarify that all rights being kept open will not include the right to again raise before the arbitrator this spurious argument that because the IOC claim was quantified at 1 rupee, the liability stands extinguished. That's all we want. And this issue, this issue was suppressed from your lordship, having been settled by a coordinate bench.
1 second. You are not either appearing for Arcelor nor are you appearing for IOC.
That's the point, Malas. That's the point.
I'm only on the question of law.
In section 11, you intervene with an MA and you want us to clarify something. How can we do it? And anyway, that order which we have passed is only inter partes, not an inter.
Now I'll deliver the killer line, my lord. What happened was that on that day, it was suppressed from your lordship's bench by counsels who are also counsels in the coordinate matter where the question of law has been settled. There's a three...
But that's all right. If that is settled, that will apply. There is no adjudication by us.
My lord, it was settled not in the nature of an absolutely crystal clear enunciation of the law. It had a flavor of being applicable to that particular matter. So all we're asking your lordship to clarify is that all...
Section 11, we'll be breaching judicial discipline if we start now intervening at the behest of a third party. You are not bound by the arbitration.
Aware which party
you are standing outside the arbitration. between you and whatever remedies your client has, you can pursue in accordance with law.
My lord,
This
I
is
would-
an arbitration between Arcelor and IOCL.
My lord,
How can we give you a locus in this?
I'll answer, my lord. I would have filed my own
Stop
SLP.
that. We'll go on to the next matter. We made it clear. But we are not passing any order. Registry to deal with the MA in accordance with law. That's all.
Very well, ma'am.
What fresh SLP? There's a fresh SLP, Union of India, as well as contempt orders against CPWD Director General Manoj. In our contemplation, we have complied with the order. It's a fresh one. May I request for any early date as convenient? And
Yes, we'll get it.
we'll circulate a mail and give it.
Madam, may I just
With
conclude
my
that
Lord's
mention?
permission, may I mention the property owners matter? It was listed yesterday for pronouncement of judgment. My Lords, due to a
Not listed yesterday, pronounced also.
My Lords, the judgment was pronounced yesterday, my Lords. My Lords, due to a technical glitch, the OTP could not be generated within time, and we were unable to give. We have told the court master as well. We may be permitted.
Recorded.
Yes,
But did that person appear actually in the matter?
yes, my Lords.
Who was there?
My Lords, Mr. Zal, we were assisting Mr. Zal.
Mr. Zal,
Sorry,
Zal-
Mr. Devrajan.
Zal's appearance is not shown in the matter?
My Lords, the order does not record the appearance, or only it records the appearance of the AOR Parekh and Company. My
All right,
Lords.
no
He
difficulty.
was there, my lord.
He was there.
Virtually also he was there.
Yes, yes.
Yesterday he was there.
And Mr. Sameer Parekh was here in the court yesterday.
Parekh
Yes,
was there.
yes,
Mr.
yes.
Sahab was also
All right.
virtually
Take it. No difficulty.
Grateful, my Lords.
On 4th and 5th, Lordship, item number 36 was listed as an arbitration matter, but it could not reach. Lordship, may I request for tomorrow or day after?
We'll see. We have a little time.
Send an email also.
All right.
I apologize if I took up too much of your lordship's time, my lords.
No. Don't give us anything. No papers are taken in the court.
No, it's
fine.
only that mentioning memo, my lords.
That's all right. You can just, you can send it on whatever. Yeah.
Much
Item 1.
Arises out of a letter petition.
Okay.
1 minute, huh? Put it here. Hold on to it. May I just not put my points across first? My lord, I had actually, in fact, let me start, my lord, with the thing. On 4th of October 2019, I had filed 2 letters, one before your lordships, which has led to this suo motu writ petition. I had also written a letter to the National Human Rights Commission, and the National Human Rights Commission has passed some interim order, which the state has refused to accept. My lord, 4th of October 2019.
Okay.
But this also arises from the same letter written on 4th October 19.
Right.
Now, my lord, may I just indicate what the points are? My lord, this was a case where demolition has been carried out of the entire house of the petitioner. When there was a right of way, etc., claimed, he had already removed it, but let's assume the worst against me. Without, admittedly, without a written notice of demolition, carried out the next day, the entire house has been demolished.
When was it demolished?
My lord, it was demolished on 13th of September 2019.
Yes.
Now, the entire, as I said, the entire house has been demolished. So, my lord, a case where demolition without notice is actually not contemplated in any, my lord, any municipal law, any National Highways Authority Act, nothing. No question of acquisition of the land either. And the NHRC, when I went also, as I said, parallelly before them, got a report, my lord, called for a report because obviously they have to carry out, my lord, the factual determination. And in that report, the following findings have arisen. I'll show that to your lordships. In fact, the other side only has filed that report. Number 1, no notice given, only a public announcement on loudspeaker was made. So, finding of fact number 1 of National Human Rights Commission, no notice given. Second, my lord, finding of fact that my house was not built on encroached land, it was my own ancestral land. This is page 150 of the counter. I'll show that I've got it all. I'm just putting the points across. Thirdly, my lord, I had requested them, rather my mother had requested the DM not to carry out this demolition 1 day prior when he said he's going to do it the next day. And most importantly, NHRC says that there was such a grave urgency to do it, but there was no road widening taking place at all there. NHRC also says there was grave urgency of road widening, but in fact they found on the spot that much later on this report of the NHRC, which I just pointed out, is dated 3rd February 2020. There was no road widening happening at that stage. Point number 3. And so, my lord, they gave me, my lord, interim compensation of 5 lakhs, etc., etc. and said departmental inquiry should be taken against the collector. The state files a writ petition in the Allahabad High Court. They don't come before the Delhi High Court or anything. They file a writ petition before Allahabad High Court. Only notice is issued, no stay. And on every occasion after that,
Who filed the
the state.
Not by any child.
No.
By the state.
State, this is between me and the state. And
Right. Before Allahabad High Court.
Allahabad High Court. And after that, only notice was issued, Lord, on 9/9/20. And since then, they've only taken dates in that writ petition, no stay. They've not paid me that very minimal 5 lakhs interim compensation that NHRC said, point number one. Secondly, my house is gone. And since that date, the matter was listed only thrice. They took dates. Matter has not been listed at all in the Allahabad High Court.
Lordship, may I?
Just 1 second, I'll just complete. I'm just completing the narration file. Then, my lord, I also wrote letters to the state saying that now you take some action. The commissioner of Basti, who is the superior officer of the collector, gives 2 reports, which are again on record, and I'll show them, that the collector acted completely in violation of all norms, law, etc., and that action should be taken against. So he gave 1 report, collector made a representation, commissioner reiterated his report. These 2 reports are, my lord, dated 21/3/20 and also, my lord, 31/7/20. And one last thing, they went in review before the National Human Rights Commission, which was also rejected. National Human Rights Commission said there's no question, our order is right. That is dated, my lord, 6/7/20. Everything is on record. I'll take 6/7/20. Now, everything is on record. If your lordship permits me, I'll take you through each of these.
Now, how does the matter come? It's a suo motu writ petition.
Yes, so he had written a letter. We are only appearing as lawyers subsequently, but the letter, though not very legally drafted, etc., it's by an individual. It came before your lordships, and your lordship registered it as a suo motu writ petition.
Right.
And incidentally, my lord, I should also point out that the stand before the Allahabad High Court, though it's not strictly before your lordships, is that NHRC recommendations are only recommendatory. We have no value at all. Again, in the teeth of a judgment of Allahabad High Court, incidentally, your lordship is the author of that judgment, that you cannot treat these as recommendations, they have to be implemented. In fact, I'll just hand over a copy of the judgment if I may. It happens to be that it's your lordship's judgment. But
anyway, we have a writ petition now in the article.
Yes, so this is the present. So that has to be decided, which is not being decided for the last 4 years.
Has the road been constructed where you are?
Now it has been constructed, and not only has it been constructed, no acquisition has taken place, and they've in fact now presently built what is a side lane now after the road itself. So I have today, after my entire house is demolished, a very narrow strip of property left. In fact, let me show some pictures to show what the demolition was like. If your lordship looks at the rejoinder that we have filed, please have a look at
what do they say in the counter. Let's see now. You have not filed a petition as such. It's only that letter which.
It's only. I'm sorry, we could not. It's not very happily worded. Also, therefore, I'm not really.
Okay, but now what do they say in their counter affidavit?
So in the counter, they say that we have gone before Allahabad High Court. Point number 1.
They have gone before the Allahabad High Court
against national. So they are saying that I have taken 2 remedies. Essentially, what they've said.
Who has gone before the Allahabad High Court?
State.
The state has gone.
Yes.
We have also lordship which has been withdrawn.
You filed a writ petition.
I had initially gone to Allahabad High Court and withdrew that petition.
Okay.
So I have not gone before the Allahabad High Court in that sense. Today I'm not.
What did you go to the Allahabad High Court?
I went against demolition. Then I withdrew long ago. I withdrew and went to these 2 places.
Oh, I see. And then our court entertained it.
Yes, so I'm not a petitioner before Allahabad High Court today at all.
Right.
No question.
Now, what do they say in their counter actually?
So now let me just point out what the counter says. In the counter, they're essentially saying.
Where is the counter?
My lord, there are 2 counters. Your lordships may kindly see the counter of the DM, which is, my lord, separately. Just open that.
Page 1.
Yes. If your lordship are to turn to
counter affidavit on behalf of the district.
Yes, page 39 onwards, my lord, if I may just read that. That's the issue.
Show us because it's a 44-page counter.
Yes, I'm just showing 1 or 2 pages. In fact, just come to page 39 directly. Now, in fact, my lord, let's come to 38.
Just 1 second.
38, my lord, which is PDF 43, I think. Yes.
Yes, PDF page 43.
So I'll just read the headings of it so that your lordships know. One, that I am an encroacher. As I said, NHRC said I am not an encroacher. So I am an encroacher because I am a co-sharer in the ancestral property is the case. Point number B at page 39 is that they gave due notice. Now, what is that due notice is very important. Kindly turn my notes to, I'll read para D at page 39. It is respectfully submitted that after identifying the right of way, it was found that of the total sanctioned length of 21 kilometers, 4 kilometers length was following in Maharajganj town. Several persons were identified to have encroached upon the land of NH 730. Out of them, petitioner so-and-so was also identified to have encroached upon the land. All the encroachments...
Where is this that you are reading?
I am reading PDF 44, para D.
Yes, just read it again, please.
Yeah, I'm so sorry. That it is respectfully submitted that after identifying the right of way, it was found that of the total sanctioned length of 21.120 km, about 4 kilometers length was following in Maharajganj town. Several persons were identified to have encroached upon the land of NH 730. Out of them was the petitioner complainant, was also identified to have encroached upon the land of the national highway. All encroachers were directed to remove the encroachment by way of announcement, Munadi, from June 2019. Specific announcements were made from 25/8/19 to 30/8/19, 1/9/19 to 6/9/19 for removal of encroachment by National Highway so and so so on. So according to them, this is good enough notice. Now, my lord, the next point is, then they say that instigation, manhandling, etc. They are saying that I don't think that's very relevant for the merits. And then finally at 43, which is PDF 48, they are saying I should file a civil suit for damage. This is the main case at page 48 PDF.
They said they visited the house on the evening of 12 September 2019.
That's correct. By which time I had already removed that 5 feet area. But in any case, with great respect, they can't demolish my house without a notice.
Where is the order of NHRC?
Yes, in fact, I wanted to show that to your lordship. Once your lordships are done with this, I'll come straight to the
operative part, the direction.
I am coming only to the operative part. Please come to page 149 of this same document.
Same addition.
Same. They have filed.
PDF?
Same, I'll just give the PDF. Just give me 1 second.
So what they say basically is that your client was an encroacher.
Yes.
That this fell within the right of way.
Yes.
And that they gave oral announcements. And then the previous evening they told your client that please remove the encroachment.
Now, my lord, may I just come to what the NHRC has said on each of these findings, which is at page 154 PDF. PDF 154, no? Yes. PDF 154, no?
Discuss?
Yes. So the issues are also set out and then the discussion is also there. So there's the answer to each issue. May I read issue para 8, issue-wise discussion, whether any notice was given to the complainant or sent to him before demolition of his property, whether his house was demolished without prior information. As per statements and documents collected during the inquiry, it reveals that no notice was served to the complainant or the residents of the said locality. However, the residents were informed about removal of the demolition encroachment through public announcement through loudspeaker. Officers and staff of NHPWD and DM office accepted that no written notice was served to the complainant and his neighbors when house was demolished on 12/9/19 and 13/9/19. Now, below the next one. Whether the house of the complainant was built at unauthorized land or government land. As per statements and documents collected during the inquiry reveals, house of complainant was constructed on land bought by his grandfather via a registry in the year 1960 and 1964. From spot inspection and measurement and done by revenue department officials in the presence of NHRC, it reveals that complainant had encroached about 3.7 meters government land in length. Demolition of 3.7 is justified because his land was under 16th width of the road. However, house of complainant was demolished after 3.70 meters, where it was 5 meters from government land and somewhere it was up to 8 meters. Thus, it was between 5 meters to 8 meters. Next, whether only the house of the complainant was demolished, they say others were also demolished. Then, next point, which is 9. Whether complainant had sent a notice or complaint to the DM and other authorities that he should be given information and time before start. I am now on PDF 157, point number 9 below. I am just skipping 3 because 3 is whether other houses were demolished. Answer is yes. I am not really concerned.
Yes, findings.
Yes, yes, this is at 156. Whether complainant had sent a notice or complaint to the DM and other authorities that he should be given information and time before starting demolition. in the complaint stated that he requested the DM to give some time for evacuating the house. No time was given to him. Then DM did not turn up during the inquiry, so his version could not be obtained or recorded. However, mother of the complainant had given a complaint to DM prior to demolition of the house. Next, whether the road of NH 730 has been widened where demolition was done. This is now a report of February 2020. As per reports of district administration, NH officials and spot visits by NHRC inquiry team reveals that road widening work at the alleged place has been stopped and presently no work is going on at the particular area. 6. Whether compensation has been given to the complainant and other residents whose houses were demolished. As per statements of complainant and other residents of the locality, NHPWD officials and district administration Maharajganj recorded during the inquiry reveals no compensation is given to the complainant and other residents whose houses were demolished. Whether sufficient time was given to the complainant to remove his household items and articles. And here, my lord, let me read. As per statements and documents collected during inquiry, it reveals that district administration made public announcement from so-and-so to so-and-so and 1st September 19 to 6 September 19 that as per order of DM Maharajganj, all residents and occupants of the area are hereby ordered to demolish their properties up to 16 meters on both sides from the center of the road. Mother of the complainant submitted complaints to DM and police by the complaint dated so-and-so. Demolition, encroachment, removal was started on 7/7/19. First encroachment by government officers was removed. Most of the area residents of the area demolished their properties themselves. On 12/9/19, demolition was carried out again. Demolition team also reached the house of the complainant. However, due to darkness and complainant started demolishing the house himself. House of complainant was not demolished that day. On 13/9/19, the house 16 meters from center of the road of the complainant was demolished. Video clip provided by government officials of NHPWD reveals that house items as alleged by the complainant were in the house before starting work of demolition. On the other side, complainant has claimed he was not given sufficient time to remove his articles, medicines, etc. And then, my lords, are the findings on the same lines. And the recommendations are at page number. In fact, my lord, out of the findings, can I just read 3 or 4 if your lordships don't mind?
Yeah.
It starts at 159 PDF and I'm coming straight away to, my lord, Roman 21 at PDF 163.
Come to 167.
Let me come to 167. Yes. My lord. The recommendation your lordships are asking me to read, yes. In view of the above, if approved, the case may be placed before Honorable Commission. Commission may consider the following recommendations: to issue notice under PHR Act to Chief Secretary Government of UP for granting interim compensation to the complainant for loss accrued to him in terms of land, constructed house, etc. Second, to direct DGP to get an FIR registered on complaint given by complainant to the district administration and get investigated by CBCID UP. To direct the Chief Secretary Government of UP to take departmental punitive action against the errant officials of district administration who dispossessed the complainant of his house and caused him property loss without issuing notices in advance, with no monetary compensation, not following due process of law while acquiring any property for government use. By the next order, NHRC granted me only 5 lakhs as interim compensation, which also, as I said, has not been paid. And, my lord, may I now just show one very important independent document. May I show one very important independent document, because that is by the Commissioner of Basti, obviously not something to do with me, who has done so. Now, if I may request your lordship to come to my rejoinder, it's a different document, my lord, very sorry, we placed it there. Rejoinder, please. Page 33, rejoinder. Your lordships have the rejoinder PDF 34, my lord.
Where's the rejoinder? Let's see.
Yes, ma'am. PDF 34 of the rejoinder. In fact, 35, ma'am. 35.
Yeah.
So this was a complaint I had made on which the commissioner carried out an inquiry. So yes, it's a common reason. Now, this is a fairly long detailed report, and I'll just come straight away to the findings here, which are at page number 42, which is, my lord, in PDF 43.
The investigation report, it's called an investigation.
He calls it an investigation report, but it's a commissioner's report.
Right. And
This was not before the NHRC and we placed it here.
Page, internal page?
My lord, internal page 42, PDF page 43. This is dated, my lord, 21/3/2020.
Oh, it is.
Put in an on-site inspection of records date, it is found that.
It is found that. So I'm not placing the entire thing, just the recommendation, just the findings. For widening of national highway in question, DPR was not prepared and making a correct assessment of availability of land requirement on the spot as per rules. During road widening, written notice should have been issued giving sufficient time in connection with removal of affected houses and other establishments, shops, whereas in this case a notice regarding removal of the alleged recruitment was not issued. Rather, on 12/9/19, before demolition in question, Duggi Munadi was made, which was confirmed on the spot. But for such a big action, Mayor Duggi, this is the announcement, my lord, was not enough. For this, notice should be issued in writing to the affected persons as per rules, which has not been done. It is accepted by NH officials themselves that 16 meters of land is to be taken from middle to both sides for junction. According to revenue record, there is only 16 meters width, 8 and 8 meters from the middle of the road of land available on the spot. In such a situation, legal process has not been followed for additional land. That is to say, acquisition. In the construction of the questioned land, as per the rules, compensation of landholding and other ownership should be determined, which has not been done. Officials of National Highway demolished the complainant's house by getting support of the district administration in an illegal way by hiding true fact, which is not fair. On so-and-so, Lakshmi Devi, wife of so-and-so, presented a letter before the then district magistrate and it was conveyed that so-and-so was being marked out of the road. In this regard, no information and prior notice has been given to them. If land is acquired by damaging the house, etc. of the applicant, appropriate compensation should be provided to him. According to the record, no action was taken at this time, due to which dispute in question arose. Construction should have been destroyed only after determining this relationship and after determining and distributing compensation, which has not been done. Therefore, the then district magistrate Maharajganj seems guilty for not following the procedure laid down in the case in question. Then, my lord, finally he says, I'll read the next para. As far as question regarding complainant attached at different levels presented with appointment section 5 of UP government letter dated so-and-so, it is worth mentioning that in complainant letters addressed to Director Enforcement Directorate, Honorable Prime Minister, etc. This is not relevant. So he's not made any comments on this. Obviously he can't. But this is what he has said, against which the DM made a representation to him again, that you've not considered my case. And that, my lord, he decides on 31/7/2020, which is at page 45, which is the next page. And I'm just requesting your lordships to come straight away to 47, which is PDF 48. And the bold portion, my lords, I'm reading. It is clear, if your lordships have that. And this is, it is clear that before providing the above administrative support, the then district magistrate had full responsibility to investigate the fact from the revenue records that whether the land on which the National Highway is constructing a road claims to be in their ownership belongs to them or not. Without verifying the same from revenue and tehsil records, the house in question was demolished through police and administrative support, which was not appropriate from any viewpoint. During the terrestrial inspection, it was found by me that the width of the road at the site in question has been reduced. Place where the complainant's house was located is not mentioned as a road land in the maps. Responsibility of demarcating and fixing the land belongs to PWD, is to the then district magistrate. Therefore, representation statement furnished by the then district magistrate so-and-so to the effect that he had no direct responsibility in the case in question cannot be accepted under any circumstances. Therefore, the representation submitted by the then DM is not acceptable at all. So he rejects that also. Now the state has taken no action against this gentleman. State has taken no action on any of the recommendations of NHRC. Matter, as I said, pending before the Allahabad High Court for over 4 years, and after 2021 not even listed. They took 3 or 4 dates. I got each of those orders. Every time they have taken a date. And therefore, we are before your lordships, and I'll just read my prayer in the letter. As I said, it's not very happily worded. It's an individual. Please forgive the language. But this is what he wrote. Not a lawyer drafting it, so your lordships will forgive this.
Just come to page 287 PDF
of the rejoinder.
This report which we were reading. After scrutiny and on-site inspection of records related to the case 1, 2, 3.
Sorry, I just don't have a running page. Would your lordship just let me know which documents your lordships are?
The very same document which you are reading right now.
The commissioner's document letter? Yes, I'll just come to it. No, not this. Yes, but I'm just coming to it. If I may ask your lordship, sorry, sir, how the para begins? Yes. Where is it here now? Which is
3. And make us understand.
where is 3? Page 40?
Accepted by national highway officials themselves.
Yes, sir.
That 16 meters of land is to be taken from the middle.
Yes.
So from the middle of the road,
16
meters on the left,
yes.
16 meters on the right.
Yes. But what was actually available was only 16 in all.
So therefore they extended it.
Therefore they have illegally taken my whole house out of the thing. Now, this exactly that's my only explanation I can give to this. Of course, they have to explain.
So the road itself is of 16 meters.
Yes.
Therefore, if you take the epicenter, it will be 8 meters and 8 meters.
Rather than 32 meters in which you do 16 and 16.
Now today, some part of the house still remains as it is.
My lord, now what is left is out of a full frontage, I have got a very narrow sliver.
Now, is the road passing through?
Now, that road is not passing through it. They have now built a side road. And no compensation to me. And nothing. Obviously, my lord, now I'm left without a house, I'm left without compensation. This is the situation.
Lordship, may I just...
But this is what I want to say.
Yes, ma'am.
I wanted to submit at the very beginning. I could not interrupt. This matter was last listed on 4 January 2021. It's coming up after almost 4 years. Just 5 days back, there has been a change of panel counsel. I have received some documents yesterday itself.
You filed a counter, ma'am.
Yes,
You
yes,
can't
sir.
now, after you filed a counter, you can't say that I've got some documents.
I just wanted a short accommodation. I'd get instructions because there's a writ petition already pending in the Allahabad High Court against the NHRC order. And
NHRC order you have challenged before the Allahabad High Court.
And
now take it for a moment that the NHRC order is incorrect. We will proceed on that basis. At the highest you can get that order set aside. Anyway, NHRC is only a recommendatory body. Right? It's not like an enforceable decree or anything like that.
NHRC can't.
So there is a judgment by me in the Allahabad High Court saying that look, you can't just, state governments can't treat the NHRC as a piece of paper, worthless piece of paper. It's a statutory body. But be that as it may, we are cognizant of the fact that there is a writ petition pending against the NHRC order. But now we have a situation where we have your own commissioner, the Commissioner Basti has investigated the matter. You say that, well, he was an encroacher. There was an encroachment of 3.7 meters. We take it that, we are not giving him a certificate for it. There was an encroachment of 3.70 square meters. How can you start demolishing people's houses like that?
Lordship, if I may.
Complete lawlessness?
There was also
You just walk in and you demolish somebody's house?
Lordship,
no notice.
Another short submission, Lordship, which has been, I just wanted to point out the first writ petition which was filed by him. Exactly similar prayers were made before the High Court. It was dismissed as withdrawn and it has attained finality, Lordship. I just wanted to read out.
When is that order? Show us that order.
The order is at page.
It's to your counter, ma'am. Ma'am, what's your name?
Tulika Mukherjee.
Now show us the...
Lordship, if I may be permitted to show the prayers which I have quoted in my counter affidavit, page 15.
Okay. 124.
Lordship, may kindly have page 15 of my counter affidavit.
Counter, we just look at it 1 second.
Lordship, that is their prayer, the writ petition that they had filed before the High Court.
What annexure would it be to your counter?
This is their prayer. It's quoted in.
Okay, just on your counter, you have annexed it. What annexure is it to your counter? Annexure A1.
The writ petition, the copy of the writ petition has not been made a part.
You got the order.
The order is P12 124.
PDF.
Yes, Your
Lordship. PDF 129.
129 of the counter.
Of the counter.
Of the counter affidavit, Lordship.
Let's see that.
So this first writ
Yes,
petition.
that is the order passed by Justice Pankaj Mittal, as my lord then was, and by Justice V.
Yes,
Dixit.
yes, Your Lordship. This is writ petition 1335 of 2020.
To withdraw the writ petition, or the petition is dismissed, is withdrawn.
This has never been challenged, Lordship, and Lordship may kindly see the prayers which I've quoted in my counter affidavit, page 15.
129.
Exactly similar prayers have been made, Lordship.
Date of the NHRC report?
My lord, the first report is dated 3rd February 2020. 3rd February 2020. And the second report, which is the review report, is 6th July 2020.
Else that you wanted to show us? In that
Yes, Lordship. Lordship may kindly come to page 15 of my counter affidavit. I've quoted their prayers in the first writ petition. If Your Lordship may permit me, I'll just read it out.
Page 15.
Page 15. Issue a writ or direction in the nature of certiorari calling the records relating to the acquisition and demolition proceeding relating to the house of petition and for quashing passing appropriate order. That's the first. Then issue a writ or direction in the nature of mandamus commanding the state government to take appropriate action against respondent 5 and 6 in particular and other erring officers involved in forcibly demolishing of the house of the petitioner without following due procedure. Then it says issue a writ or direction in the nature of mandamus commanding the respondent to pay compensation and damages to the petitioner and be recovered from the salary of the erring officers. And then it goes on.
Why did you withdraw the writ petition before the
Because, my lord, I had subsequently approached on 4th October 2019 both the NHRC and Your Lordship. Therefore, I just withdrew it because there's no point in having a third remedy if I'm coming in writ petition before the High Court.
What is the date of your letter?
Yes, the date of the letter is, my lord, 4th October 19, which is after the writ petition. Therefore, I withdrew the writ petition.
And when did we take suo motu notice?
And yes, absolutely. That was, my lord, I'll give the exact date. That Your Lordships did on 7th December 2020.
This fact was not brought on record by the petitioner Lordship when Your Lordship were pleased to.
And when did you move the NHRC?
On the same day, 4th October 2000. We wrote 2 letters on the same day.
To this court and the NHRC.
Yes.
Therefore, in that view of the matter, you.
Yes.
And the NHRC report is subsequent to the withdrawal.
It's subsequent. Everything is subsequent.
The house?
The side just asking. He's here.
Roughly?
In fact, I can show the photograph. It's a fairly large property. It's a fairly double-story property. 50 into 80 feet.
15 into?
50 into 80 feet. 50 into. It's a large bungalow.
Which year it was constructed?
4,000 square feet.
It was constructed in which year?
1960s.
60?
Yes, 60s. Because we bought it in 60 and 64 after that. Land was
which year you said?
No, it was bought. The land was bought in 60. After that, immediately in the 60s, it was constructed. 60.
In the decade of 60?
Yes, decade of 60. Old house. There are some photographs of the house if your lordship wants to have a look at. You can show.
Same man.
Just a request, Lordship may keep this matter after 2 weeks because I have also got the file just yesterday.
What else do you have to say apart from that? We've got your affidavits now on the record.
Lordship, I understand.
Completely high-handed. Somebody's property is destroyed without any demarcation, without any acquisition. What is the due process which you follow? You say that you have only, issued a munadi, which is a beat of the drum.
Lordship.
That's not the way. People's properties have to be.
I may be permitted to seek instructions whether any notices were sent besides the munadis.
We have affidavits saying that no notice was issued. You say that we only went to the site and informed people. That's all.
From 2019 to I think September.
That's all that you have said. If there was a notice, you would have said in your counter affidavit. This is what your counter affidavit by the district magistrates.
I understand, Lordship.
And
however,
properties are entitled to some.
I understand, Lordship. However, I am just seeking a 2 weeks accommodation. I do not want any.
Time, because it's a matter which has been completely, the affidavits have been filed, rejoinders have been filed. Forget the NHRC for a moment.
Gotcha.
Because NHRC made its own inquiry, but that is subject matter of challenge. But what about the commissioners and the commissioners? The commissioner's report is not denied.
Lordship.
For the state.
The state, I mean, how can the state carry out these kind of activities? What are your prayers in the?
Yes, my lord, I wanted to show them. It's rather unhappily worded. Please have a look at PDF 10 of the letter because that's the petition. I hesitate to read it, but I will. If your lordships have it, I'll read it. So, this is, you are humbly requested to get a CBI inquiry. So, he wants an independent inquiry conducted against DM who has flouted human rights, inflicted severe tyranny, injustice, torture, and heavy humane.
This is internal page?
My lord, this is internal page. My lord, this is the last page of that. The second last page of that of the complaint. Sorry, there is no para number here. I have a copy. If your lordship wants, I can hand it over. This I have a print of. Just because I know this might. Just give a print of. This we have.
Yes, Chief Secretary, Government of Uttar Pradesh.
No, my lord. It starts. Can I just hand over? My lord, it's just a few pages. I'm very sorry. Normally, I would read it from here. Your lordship would indulge me only for this. This is, my lord, the 4th October 19 letter petition to my lord, the Secretary General of the Supreme Court, my lord. And if your lordship would just come to the last but one page. This is his prayer. The one in bold.
Yeah. We may be inclined to award punitive compensation to your client. Would that serve the ends of justice?
Just one other thing your lordship may consider, because this is what the commissioner has also in a sense recommended, is the departmental inquiry aspect and whether some independent, of course he mentioned CBI, but that's all right. Your lordship may have some independent inquiry into it. If that's those are my only two additions.
Now why independent inquiry means we'll be reopening whatever is concluded in your favor.
No. So very well, so my lord, let them act on the commissioner's report. Commissioner's report has to be acted upon.
Has to be taken.
That's what I meant, yes. Because otherwise that report remains a dead letter without any.
Absolutely, because there has to be some
There has to be
accountability.
some.
There has to be accountability.
Yes, that's why we said independent, but that's fair enough. Commissioner is, as far as we are concerned, all right, no problem. He's saying CBI, etc., but I'll leave it to him. Forget. He said that the entire action was by malicious and so on. The entire action of proceeding against him was malicious. That's what he says. Forget just the demolition, the way it was done, everything.
How many houses did they demolish like that?
Total कितना पूछी? नहीं और कितने थे? हाँ? ये total कितने थे?
There were 123 illegal encroachments on that road. That is what the counter affidavit says.
Determine that they are illegal constructions. Show us what is the basis for you to say or put forward this case that all this construction was unauthorized. Show us.
From our counter affidavit.
Not from your counter affidavit. What is the basis for you to say that this was unauthorized?
Which is why, Lordship.
What inquiry did you undertake?
Lordship, if I may be just given some time to get instructions.
It is your case that the constructions were unauthorized. What were you doing from 1960 till 2019?
Lordship.
For all these years, you never realized that this is all unauthorized?
Lordship.
You claim the land of your ownership, that this construction was put up on the land owned by the government. Is that your case?
Lordship.
Then what were you doing past 50 years?
Which is why, Lordship, I just wanted a very short adjournment by you.
Sorry. Very high-handed action. Very high-handed action. And today we close our eyes to this. Tomorrow the same thing will happen in the state. We can't tolerate this.
We'll bow down to whatever your Lordship.
In fact, you appear for the state. It was expected of the state to take appropriate action immediately.
Lordship.
State has to show some respect to the National Human Rights Commission's orders also.
Yes, your Lordship.
Sit tight to, you are thereby protecting an officer who has acted in a very high-handed manner.
Lordship. We'll bow down to whatever your Lordship may decide.
A suo motu writ petition was registered before this court under Article 32 of the Constitution on a letter dated 4 October 2019, addressed by Sri Manoj Tibrewal Akash, complaining of the demolition of his of an ancestral residential house and shop situated in ward number 16, house number, of his ancestral house and shop described as house number 177 in ward number 16, Mohalla Hamid Nagar, district Maharajganj. Stop. Notice was issued of the writ petition after the letter was registered as a writ petition. Note dedo, writ petition civil number 1294 of 2020. To the district magistrate Maharajganj, to the district magistrate and the superintendent of police of district Maharajganj. Full stop. In pursuance of the proceedings which have been initiated before this court, One counter affidavit or how many?
There are two count.
Sir, affidavits have been filed by the district magistrate and the superintendent of police,
Yes.
which have been followed by a rejoinder by the petitioner.
What do you mean? नहीं मैं नहीं कर सकता बोल दिया
Petitioner 1975.
Milord, we had filed, there was a suit filed because there was an inter-se family dispute in which there was a stay order passed of 75. We had pointed that out when we wrote to the DM, rather my mother wrote to the DM that there's a stay order, to which he said, because of Asian resurfacing judgment which was enforced at that time, that stay order was not extended, therefore I'm coming to demolish anyway. So that I didn't point it out because that was an aside in itself.
Was dismissed.
94 देखा ना काउंटर का 94
Babulal and others, Shubkaran and Sushil versus
Yes.
State of UP. What is that?
Yes. That actually arose out of, as I said, Milord, the partition proceedings between the parties. That order is at page 94 of the counter. Please have a look at that itself.
PDF.
PDF 99.
It was an interim order.
It was an interim order which says that because it's pending, etc. But when we pointed this out saying that it's pending, they said that this order was not extended from time to time because of Asian resurfacing, therefore we will not list it.
But the petition was dismissed, or what happened?
What is happening?
It was dismissed, Your Lordship. From
Yes?
It was dismissed.
It was
What was the prayer in that writ petition?
What was the prayer in that? मुझे बताइए नहीं वहाँ नहीं मुझे बताइए. Okay, so he says that even at that stage in 17, it was contemplated for widening, so he went and got a stay there, which was then this thing. So,
Because Lordship,
my application before the DM says that if your lordship will just look at page 92 of the same document, same file, my lord. This is the my lord. Sorry. Where is Asian resurfacing mentioned?
It was only in the state highway was pre-existing, and it was in the year 2012 that a notification.
You know what you did, ma'am, your officer.
Not sure.
Previous night, the team must have come. They demarcated the portion which they wanted him to demolish for the purpose of widening. Right? That was about 5 feet or something.
Not sure.
He demolished it in accordance with that yellow marking.
Not sure.
Other people also demolished those portions with the yellow marking. After he demolished on his own volition, next day you come with bulldozers and you demolish the entire.
Yes.
Now what you did was, this marking, yellow marking was in accordance with the revenue records, because the road is only of 16 feet wide, 16 feet or meters.
Meter.
So if you take the middle of it, 8 meters on left, 8 meters on right, you ignored the revenue records. You took it as if it is 16 meters on right and 16 meters on left, and you demolished everything. Then what was the idea in putting that yellow marking? What was the idea behind it? You did it, they demolished it. Next day morning, to their misery, the bulldozers come and they demolish. This is what.
As per our count, 123 houses were demolished. This is one of the reasons why we are seeking an independent inquiry into. Of course, I have come for one house. 123 houses in a row, which is why we've sought this.
If you want it for the purpose of a genuine public project, you can do it. But then there's a procedure for it. You have to issue a notice. You have to call for their objections. It is like acquisition.
Yes,
you can't come with bulldozers and demolish the construction overnight.
Must fairly submit has not been done. So that I.
You don't give family time to vacate. What about the household articles inside the house? All this, where will they put it?
I just wanted to clarify with respect to widening that it was in the 2012, the notification.
All right, widening was just an excuse. It doesn't seem to be a genuine reason for undertaking this entire exercise.
Although the notification we have placed on record, Lordship, the 2012 notification that we have placed on record as annexure CA2 and 3.
And what is this Munadi?
Munadi is announcement.
The days of Munadi are gone. Munadi is good enough for execution of a decree passed by a civil court.
Yes, Your Lordship.
You can't just on a bit of a drum tell someone, okay, vacate the house, we are here to demolish it.
That I must fairly submit that.
Something like a rule of law?
Yes.
According to the full stop, the affidavit filed by since the petition has been registered on a letter written by the petitioner, and to obviate any controversy in regard to the facts, we would proceed on the basis of the facts as are revealed in the counter affidavit filed by the district magistrate. Full stop. The affidavit discloses that on 7 March 2012, the state highway commencing from district Pilibhit via Bharej, Balrampur, Maharajganj, and concluding at Padrona, page 8 ko mil jayega counter ke, was notified as National Highway 730 under the National Highways Act 1956. Prior to that notification, the road in question is stated to have been a state highway. On 13 March 2018, a final DPR for widening NH 730 from KM 484 to KM 505.120 is stated to have been prepared. with an applicable right of way at the aforesaid chainage of 30 meters. That's what you have said, no? 30.
Yes, Your Lordship, 30 meters.
The Union Government of India following a sanction by the Government of India on 13 March 2018, an agreement was executed on 2 May 2018 by the State Public Works Department with a concessionaire, with Messrs. Mahakaleshwar Infratech Private Limited, bracket MIPL, for the execution of the work. The work order, it has been stated, stipulated the commencement of work on 18 February 2019 and the date of completion as 17 February 2020. According to the district magistrate, in June 2019, it was found, after identifying the right of way, that out of the total sanctioned length of 21.120 km, about 4 kilometers of length fell in Maharajganj town. Full stop. Several persons were identified to have encroached upon the land of NH 730, including allegedly the petitioner. Thereafter, according to the collector, an announcement, according to the collector, an announcement was made by, a Munadi announcement was made, into brackets, by beat of drums from 25 August 2019 to 30 August 2019 and from 1 September 2019 to 6 September 2019.
From June 2019, Lordship, just the sentence above it started from.
Munadi announcement was made from June 2019 and from 25 August. On 4 July 2019, it is alleged, the mother of the petitioner made an application to the district magistrate requesting him not to demolish her house by placing reliance on an interim order dated 14 November 1975 passed by the High Court of Judicature at Allahabad in a writ petition styled as Babulal versus State of Uttar Pradesh. On 8 September 2019, the brother of the petitioner is stated to have furnished a letter to the authorities recording that he had purchased the house / land, which was registered in the revenue records under Abadi land category 6.2, semicolon, that the house was co-owned by 3 persons, and that in 1975 he had instituted a writ petition in which an interim order was passed restraining demolition. However, the writ petition is alleged to have been dismissed in default brother of the petitioner is alleged to have stated that if the house was required to be demolished for construction of NH 730, compensation should be awarded. According to the collector, on the evening of 12 September 2019, the occupants of the house were called upon to remove all their belongings. And on 13 September 2019, into invert commas, the team removed the encroachment, into invert commas, complete. The petitioner is alleged to have, the petitioner is stated to have instituted writ petition 1335 of 2020 before the High Court of Judicature at Allahabad on 28 September 2019. Stop. On 4 October 2019, he moved a complaint before the National Human Rights Commission, which was registered as case number 27074 stroke 24 stroke 49 stroke 2019. NHRC constituted a team of 2 inspectors for conducting a spot inquiry, for which letters were issued to the district magistrate and superintendent of police. According to the collector's affidavit, on 5 November 2019, the petitioner's brother, into bracket Shubh Karan Tibrewal, bracket, filed a notarized affidavit in which he stated that there was a 2-storied ancestral house which was constructed in Hamid Nagar pursuant to the purchase of the house by his late father on 6 June 1964 by a registered deed in which the deponent had a 1/3 share. According to him, a registered deed of partition had taken place in the family on 25 November 1967. When in 1975, the PWD attempted to demolish the house for the construction of a road, a writ petition was instituted before the High Court in which on 14 November 1975, a division bench had passed an interim order. Since the partition could not be implemented, a civil suit was stated to have been instituted as between the co-sharers. The writ petition which was instituted before the High Court of Judicature at Allahabad for challenging the demolition action was withdrawn on 18 January 2020 before the division bench, by which date the petitioner, as already noted earlier, had filed both, had addressed a communication to this court and instituted a complaint before the NHRC.
Lordship, the brother had also given consent for demolition where he says that it belongs to him. That may also be.
According to the collector, the brother of the petitioner had given his consent for the purpose of the demolition.
Of his share.
Of his share. Of his share. He says you can demolish my share.
Easy way for him to get the partition, I suppose. That's what. Anyway, that's not the issue here.
Next. In this backdrop, it appears from the material of the record that when the petitioner moved the NHRC, a detailed inquiry took place. Full stop. The NHRC, by its report dated, what is the date of the first report?
3/2/20.
Right. 3 February 2020. Inter alia concluded that bracket 1, no notice was given prior to the demolition, save and except for a public announcement through loudspeakers. 2, the house of the complainant was constructed on land bought by his grandfather in the year 1960 and 1964. Semicolon, bracket 3. The spot inspections and measurements done by the Revenue Department officials in the presence of the NHRC inquiry team revealed that the extent of the encroachment on government land was about 3.70 meters in length, and demolition of that extent was justified because the land was falling under a 16 feet wide road. It's a 16 feet, so it's 16 meter wide road. 4. However, the house was demolished beyond the extent of the encroachment of 3.70 meters, and it appears, and the actual demolition was between 5 to 8 meters. No compensation has been furnished for the demolition of the property. 6, the mother of the petitioner had submitted a complaint to the DM District Magistrate Maharajganj and the police on 4 July 2019. The demolition action commenced on 7 July 2019. And on 13 September 2019, the house, which was 16 meters from the center of the road, was demolished. Seven, the video clip provided by the government officials of NH-PWD revealed that house items as alleged by the complainant were in the house before starting the work of demolition. the findings of the NHRC indicate that at the highest, the demolition action to the extent of 3.70 meters may have been justified on the ground of an encroachment. But there was absolutely no justification for the demolition action beyond the alleged encroachment. NHRC concluded that the government agency had failed to provide any document to support that the road width in front of the house of the petitioner was 32 meters into brackets 16-16 meters bracket from the center of the road. The revenue record and the NH-PWD records were stated to have revealed that the road width in front of the house of the petitioner was only 16 meters into brackets 8-8 meters from the center of the road bracket. However, the district administration and the officers removed demolished properties up to 32 meters into brackets 16-16 meters from the center of the road on both sides without any authority of law. NHRC therefore recommended, bracket 1, the issuance of a notice to the Chief Secretary for the grant of interim compensation to the complainant petitioner. Bracket 2, a direction to the DGP to have an FIR registered on the complaint lodged by the petitioner with the district administration. And 3, a direction to the Chief Secretary to take departmental / punitive action. Full stop. The first report of the NHRC was followed by a subsequent report dated 2 March.
No, that is 6/7/20.
Of 6 July 2020.
2 March is the show cause notice sent. The report is of 6/7/20.
Right, of 6 July 2020. Along similar lines, right?
Actually, this is a final order, an interim order. It's not a report as such. This 6/7/20 is an order.
620 and by an order dated 6/7/20.
Yes, yes.
6 July 2020. Full stop. Besides the full stop, the report by the NHRC has been challenged by the state of Uttar Pradesh in a writ petition before the High Court of Judicature at Allahabad, which is pending pursuant to the issuance of notices. Full stop. Quite apart from the report of the NHRC, the issue was investigated by the Commissioner Basti on 2 occasions. Full stop. The Commissioner Basti the findings which are recorded by the Commissioner are extracted below. ये आपको page 287 after scrutiny and on-site inspection of records यहाँ से लेकर we will go to paragraph 7. We'll conclude at page 289. Following a representation by the district magistrate, the Commissioner passed a further order dated 31 July 2020. In the subsequent order, the Commissioner observed, page 292, it is clear that before providing the above administrative support, the then district magistrate, up to the end. Therefore, the representation assertion submitted by the district magistrate, Shri Amarnath Upadhyay, is not acceptable at all. Page 293. Yes. Next. We have heard Mr. Siddharth Bhatnagar, then senior counsel who appeared on behalf of the petitioner, and Ms. Tulika Mukherjee, learned counsel appearing on behalf of the state of Uttar Pradesh. So we are not inclined to accept the request of the state, of the counsel for the state, for a further adjournment of these proceedings, having due regard to the fact that pleadings have been completed and the court is required to evaluate the materials as they have been placed by the state on the record for deciding upon the legality of the action. Full stop. The narration of facts would indicate the following position emerges from the narration of facts, : the state of Uttar Pradesh has produced no document to indicate the original width of the state highway, which was notified as a national highway. Bracket 2. No material has been produced on the record by the state of Uttar Pradesh to indicate whether any inquiry was carried out to earmark the encroachers, particularly with reference to any demarcation proceeding. 3. There is absolutely no material produced before this court to indicate that the land had been acquired before the work of demolition was carried out. Full stop. The affidavit, beyond stating on affidavit that there was an encroachment, the state has failed to disclose, bracket 1, the precise extent of the encroachment, bracket 2, the width of the road, the width of the highway, the width of the existing road, bracket 3, the width of the notified highway, bracket 4, the extent of the property of the petitioner which actually fell within the width from the center line of the highway, also from the notified width, semicolon, and bracket 4, why the demolition was required to be carried out beyond even the area of alleged encroachment. As the report which has been submitted by the NHRC at least would prima facie indicate, the demolition was far in excess of even the alleged encroachment, which was to the extent of 3.70 meters. Apart from the above, it is clear that the demolition was carried out only following a beat of only with a munadi and with no notice or opportunity, or with no notice or disclosure to the occupiers of the basis of the demarcation or the extent of the demolition which was to be carried out. On the facts that as they have emerged on the basis of the disclosure in the record by the state of Uttar Pradesh, it is clear that the demolition was completely high-handed and without the authority of law. Good stop. At this stage, it may be also material to note that the allegation of the petitioner in his letter dated 4 October 2019 to the Secretary General is in the following terms. The letter may AA. The petitioner has therefore clearly alleged that the action for demolition was a reprisal for the report which had been published in the local newspapers in regard to allegations of wrongdoing in relation to the construction of the road. So for the purpose of these proceedings, it is not necessary for this court to enter upon this aspect, save and except to flag the grievance of the petitioner. Full stop. However, full stop. Such action by the state cannot be countenanced. Full stop. Any action in respect of private property must be followed by due process of law. Full stop. Before taking action in pursuance of a road widening project, the state or its instrumentality, as the case may be, must inter alia undertake the following steps: bracket 1, ascertainment of the existing width of the road in terms of records / maps. 2, carrying out a survey / demarcation to ascertain whether there is any encroachment on the existing road with reference to the existing records / maps, semicolon, bracket 3. If an encroachment is found, the issuance of a notice to the encroacher to remove the encroachment. 4, in the event that the noticee raises an objection with regard to the correctness or validity of the notice, a decision on the objection by a speaking order in due compliance with the principles of natural justice. 5, if the objection is rejected, a reasonable notice should be furnished to the person against whom adverse action is proposed to remove the encroachment, and upon the failure of the person concerned to do so, the competent authority or state may take steps to remove the encroachment unless restrained by an order of the competent authority or court. And 6, if the existing width of road, including the state land adjoining the road, is not sufficient to accommodate road widening, steps would have to be taken by the state to acquire the land in accordance with law before undertaking a road widening exercise. Full stop. In the present case, we have come to the conclusion that the entire process, which was followed by the state, was high-handed. Full stop. We are therefore inclined to pass 2 directions. First, a direction for the payment of punitive compensation, semicolon, and bracket 2, a direction to the Commissioner Basti, a direction to the...
It will be to the state.
To the Secretary, Public Works Department to conduct
To the Chief Secretary, I was thinking.
a direction to the Chief Secretary of the Government of Uttar Pradesh to entrust, to inquire into the matter, to have the entire matter, to have an inquiry conducted into the entire matter pertaining to the illegal demolition.
Against the then DL, because now
Against all officers, including contractors who may be found to be involved, who are responsible for the illegal demolition. Stop. This would include disciplinary action against any officer who is found to be involved in the demolition, not only of the house of the petitioner, but other similarly situated properties in the area which were alleged to have been demolished in a similar manner.
according to them, there were 123. According to them.
Go to the Manoj.
The state of Uttar Pradesh shall pay to the petitioner compensation, which we quantify at rupees 25 lakhs. Full stop. This compensation would be of an interim nature and would not come in the way of the petitioner, should he be so advised to adopt any other proceedings which are available in law for the payment of compensation.
You know, the NHRC's report, your lordships have seen it, also said FIR will be registered. So that there was nothing about. So that your lordships will observe something on that, which is at page 162 of the counter. Your lordship, sorry, just read that. Those are the three. One, FIR, then departmental, and just show me 162.
The above directions shall be followed. Of the government of Uttar Pradesh will, after conducting the inquiry, take suitable action, including action of a criminal nature, where it is, including action of a criminal nature, to ensure accountability of any individual found to be in violation of law. Full stop. The exercise to implement the implementation of these directions shall be initiated no later than within a period of 1 month from the date of this order.
I'm deeply obliged. It's just that the direction was that DGP will get an FIR registered.
The Registrar Judicial shall circulate the directions which have been issued, shall circulate a copy of this judgment to the Chief Secretaries of all states, stroke UTs,
Yes,
to ensure compliance with the with the direction which have been issued with regard to the procedure to be followed. for the purpose of road widening.
So I'm deeply grateful. Manoj, just one issue, whether your lordships would like to consider saying something about the pending writ, whether it should be heard, decided, etc. Because there the question will be of the DGP inquiry also. There's been challenge there and so. Let
the High Court, whenever the High Court will deal, we have gone. Therefore, we have said that we are not going by the entirely by the NHRC. We have gone by the record which is before.
Absolutely.
We have said that it is completely high-handed, and we have awarded punitive compensation, and we have said departmental action, inquiry by the Chief Secretary of the State of Uttar Pradesh.
I'm very grateful to you.
Anything else?
Very grateful. You also spent a lot of time on this matter. Deeply.
Obliged.
Actually, because we wanted to formulate broader, I got a lot of assistance from my two colleagues on the broader directions.
Help everyone in that sense. Yes.
Obliged.
My lords. My lords, it is against gender discriminatory provision. My lords.
Mr. Jain, we'll have to. This is item 2.
My lords.
Shweta Gupta was Union of
Gender
India.
discriminatory provisions, my lords.
Sorry?
It is against the gender discriminatory provisions based on marital status of women.
We'll have to keep it some other. Keep it after 4 weeks.
My lord, may issue notices, my lords.
Item 2.
Item 2, my lords.
Fresh matter.
Fresh matter, my lords.
This for what? UP, what are you challenging?
UP and Uttarakhand, my lord. The laws are gender discriminatory. When a daughter marries.
We already had that petition under the Hindu Succession Act.
My lords.
Poker versus Union of India, which is post notice.
My lords.
If you want to intervene in that, you can intervene in that.
Because these provisions are quite wide. They are more discriminatory than merely Section 15 of the Hindu Succession Act. Because here they say that if a daughter marries, she is divested of her interest in the land. If a widow remarries, she also loses her interest in the land. Therefore, these provisions are quite wide and more discriminatory in nature as.
If you notice here.
Deeply obliged, my lord. Deeply obliged. Item number 3, I am also appearing, my lords.
Yes.
My lord, it is against the for the ensuring the compliance of statutory rule 18 sub rule 1 clause 2, which requires annual immovable property returns to be filed by the Group A and Group B officers. They are not ensuring the compliance of this statutory rule.
This is just one of your PILs. We'll not entertain this.
My lord, just see that they have a portal which clearly
we don't monitor all this now. I mean, we will be only doing this exercise.
My lord.
Yes.
Please, Milad, in a similar SLP filed by a batch of 91 students, this Honorable Court had issued an order, which is at page 241.
That on deposit of 7.5 lakhs, you will get your original document.
Yes, yes, Milad.
You are in the same in the same batch. Same batch.
Yes, yes, Milad.
We'll issue notice here and make it returnable in 2 weeks.
Please, Milad, the only urgency is that now the counselling will begin. They have paid the excess amount in by virtue of certain emergent occasions and situations. They had to apply for the counselling. The only limited direction we're asking, we'll abide by and give the undertaking.
Of our 9 September order.
Yes, yes, Manoj. We'll comply with that order and give an undertaking to the college.
Is the same college?
Same college, Manoj. Same college.
In view, issue notice, returnable on, in view of the order dated 9 September 2024 passed by this court in Sahil Bhargav versus State of, uske upar likh lo, Ms. Tanvi Dubey, then Chancellor appearing on behalf of the petitioner, submits that the present case is similar to a case which has already been entertained by this court, namely Sahil Bhargav versus State of Uttarakhand, SLP Civil number 19953 of 2024, in which it was an interim order, right?
Yes, yes.
In which an interim order was passed on 9 September 2024. Next. In view of the interim order dated 9 September 2024, we passed the following order. Then we'll just copy the order.
Yes.
So 7.5 lakhs you will have to deposit with the college, give an undertaking, and then on that condition you will get your document.
Yes, Manoj. In fact, there's an High Court order.
That order which with the operative order which we have passed is comprehensive. So that
Yes, yes, Manoj. Great.
That's in item 5. There is no impugned order yet. But what we put to challenge, my lords, was the order at page 206, Annexure P9. Can I draw your lordship's attention to order at page 206, which is the DRAT's order?
Which said that you should deposit 40% of 13 crores.
13 crores. The problem is this. The DRT proceedings there were two parts of the DRT order, my lords. One, allowing my counterclaim to an extent of 4 crores. And one, allowing the bank's recovery proceedings to an extent of 8 crores plus interest. The bank's appeal is pending. My appeal is also should be pending, but to admit my appeal, they say mandatory deposit. In normal cases where only my appeal is pending, my lords, I can understand that you must insist 40% of. But this is a case where I have gotten counterclaim awarded in my favor where the bank has appealed. There is no stay of the bank so far as those 4 crores are concerned.
DRT Vizag allowed our respondents to recover 8.2 crores.
And allowed my 4 crores.
Deducting 4 crores of the counterclaim.
That's right, lords. So
the total claim which was awarded to the bank was 13 crores.
That's right. That's
4 is your counterclaim.
That's right.
So they awarded them 8 crores.
That's right. The point is this, kindly see the DRT's order and then I show the DRAT's order. Would your lordship kindly
You've gone to the High Court, no?
We went to the High Court. The High Court has dismissed my writ, but the order is not out yet.
Where is the order?
The impugned order, it's not uploaded yet, page 1.
Keep it next week.
My auction is today. That's why we put it in urgency. It's a running factory, my lord. It's an MSME running factory.
Period for confirmation of the auction sale?
That's confirmed. So far as the factory is concerned, the auction got confirmed. We couldn't come in time. So far as the residential properties are concerned today, if your lordship say it won't be confirmed, just kindly see the notice, my lords. The paper publication is for today.
But you have been asked by the DRA to deposit 40% of 13 crores.
That's what I'm saying. There is no question of 13 crores today, number 1. Because I have 4 crores counterclaim awarded in my favor. That's number 1. Number 2, would your lordship
8 crores, suppose we were to say 40% of 8 crores.
There is one more concern there. Would your lordship kindly see the DRT's order? The DRT
anyway, let's have Mr. Parmeshwar, let's have a look at the High Court's order. Let's see what the High Court has said.
I'm only saying, your lordship says it won't be confirmed.
Why should we
say this? Only that until the order comes out, lords. Because
we'll keep it on Monday. We'll keep it on Monday. You go to the put the order. If you get a copy of the order, put it on order. Mention it tomorrow. We'll keep it on Friday.
Very well. Very well.
Keep it on Monday.
Otherwise on Monday. Get it.
6.
6, Lord. So this is a writ petition, Lord. I represent a body called Save Life Foundation. Save Life Foundation has come to this Honorable Court even on earlier occasions, Lord. The issue really relates to the 4 lakh plus injuries and deaths that take place, Lord, injury-related deaths that take place amongst the highest in the world in our country, because the trauma care scenario is not problematic. Today, Lord, if somebody was to have an accident, let's say on Tilak Marg, he doesn't even know where to go, where to contact. And then the question is, what is the nature of channelization? How is the person going to be shifted? But when many years ago, Lord, I have one request to make. Lord, just see the prayers, please, at page 65.
Yes.
Lord, there are 2 issues. Because Lord, one is, of course, I'm grateful your Lordship is kind enough to issue a notice, Lord. Please just see prayer A for a moment. Aim not is integrating, Lord, that may. Not page 65 and 66.
Establishment of grievance redressal system for Good Samaritans.
Yes, not now. This is a
Development of a comprehensive medical rescue protocol.
Yes, not D is what I'm concerned with. Not B on B. Not A and C. D will take time.
Perhaps what we can do is there is a road safety committee chaired by a former judge of our court, Justice Sapre. We can ask him to prepare a protocol for us and submit it to us.
I just say this, not in this case, not just see prayer B.
Yes.
The 134A is already there. So today is not that 134A is not there. The difficulty is not, it's a state subject.
Right.
Because it's a state subject, it's not being acted. That's why we made all of them parties. So not today, what I'm seeking is this one. There, if my lord may just consider, if the respondent state can do it within
let them come back in 2 weeks. Just stop them and come.
Well, may I just say this? But the only prayer was that if it could be done within a period of 3 months, because today what's happening is, I'll tell your lordship,
just come back come back with service in 2 weeks. We'll give you Dusty. Are the states all parties here?
Not all the states are parties. Union is a party, states party, National Medical Commission is a party.
So I was really concerned to serve the Standing Council Dusty and come back in 2
yes,
2 weeks.
And not would your lordship also consider not one more thing, not prayer K.
After notice, these are not matters where we have to pass an addendum ex parte order. Let them come here, we'll pass that order. Let the government be here before us.
I leave it to your lordship. Not we'll serve this through standing councils then.
Yes.
And serve through Senate.
Right? So, yeah.
Deeply obliged. Not grateful, not deeply obliged.
With your lordship's kind permission, may I mention
after lunch? So sorry to be late. There was something. Yes, sir.
Wherein I am a petitioner in person, and this was dismissed summarily in limine.
By who?
Because of my Lordship Justice Seema Kohli's retirement. There has to be a fresh bench. So I urge.
What do you mean fresh bench? You have to file a review or something?
Review I have filed, my lord.
It will be listed before a bench.
It may be taken up by my lords in this court.
We'll see. I'll find out what the matter is about. I'll assign a bench.
Lordship has, I'm relying upon a judgment passed by my lord in Swapnil Tripaঠি's case, wherein I'm relying upon 3 constitution bench judgments.
I'll constitute a bench for the review.
Can my lord take it unto sir by tomorrow or the day after?
Let me see. I don't know what the matter is about. Let me
Yes,
see what.
this is what I have filed. Lordship may kindly.
Sir, don't worry. I'll constitute a bench. That's my duty to constitute a bench.
Because my lord has passed these in Swapnil Tripaঠি's case, that has completely been. And I was.
All right, now follow the next matter. I told you I'll constitute a bench this evening. Yes.
I was dismissed during the pendency of a contempt.
All right.
Yeah.
I'll constitute a bench, sir. You filed it in the registry.
I've already filed it on yesterday only.
Don't give me a copy here. That registry copy will come to me.
So will my lord just tomorrow or the day after
file it here?
Judges will see.
My lords, my lords, in the present matter, the High Court had given me interim protection, my lords, and kept that 1 seat aside for me. However, my lords, in the impugned order, the High Court was of the view, even though they agreed with me on merits, but they were of the view that they may not be able to pass such orders because the such powers will be only vested in my lords under Article 142. And therefore, my lords, permission was granted to me, and my lords.
You completed the first 2 rounds of counselling.
My lords, I did. And as if I could just, my lords, explain, I have got an admission fairly, my lords, in R4, the respondent number 4 medical college.
There you've already been admitted.
My lords, I had to take an admission, otherwise my year would have gone. My lords, my claim is this, that as under R5, 100 seats after the first and the second round was over of counselling, 100 seats were added in the R5 college. Now, my lords, although I am permitted to appear in those 100 seats that have been added in R5, a corollary would be that only those 100 students will go up and there'll be vacant seats in R6. All I'm seeking, R6 college, all I'm seeking, my lords, is that as per the present, if merit is to be considered, I will be eligible for R6 college. What the
But if you accept that, then the entire process, there'll be no finality.
I could see, my
lords. No finality. Everybody would want to have, there'll be a journey all the way through.
I completely, my lords, I was preempting this query by my lords, which is why, my lords, I'm saying this may not be a precedent. In my case, there is already that 1 seat kept vacant. Please see the impugned order.
Can't do that because you've already got admission to R4.
I have to fairly admit that.
R5, there are 100 new seats.
My lords.
Now you want a seat in R6.
The consequential seats, my lords, because merit has to be considered. Now, what is happening?
You say that R6 students will go to R5.
My lords, because of the reason.
But they will have the same block as you. They can't change their
circular. If I could just explain, my lords, as per the circular, mop-up round individuals can be considered for these seats, but not me. I am definitely higher in rank. And
so you already been allotted.
My lords. My lords,
applies across the board.
My lords, upon instructions, I am saying, my lords, I quite see 1 seat is still kept in R6 college.
But once we start this, the whole process.
I see, my lords. But my lords, I had an interim protection, and look at the impugned order.
We can't look at it from the point of view of 1 student. What we do to 1 student, we have to then follow for the entire. Students across will say that, look, give me an opportunity.
I agree, my lords. In fact, my lords.
So once preferences are locked, and a seat is allotted, then that's final, except...
I quite see what's fallen, my lords, but
upon instructions... Suppose these seats were not made available, these 100 seats in R5.
I would have stuck to the college that I've got through admission. But, my lords, merit has to be considered instead of these My lords, merit has to be considered. As on date, individuals lower than me in rank would be getting the benefit of R6 college.
But these are because of these fortuitous circumstances. Now, of some college getting 100 seats later.
My lords, but in peculiar facts of this case, that one seat continues to remain. My lords, though if that seat is vacant, I should be considered. The High Court did grant protection to me.
Even the High Court felt it very difficult to ultimately grant relief.
My lords, the only reason
the Supreme Court, they passed on the burden to us, but we can't also do it. We are also bound by.
My lords, consider if it could be just be
called completely disrupts the entire admission schedule, because once we do it for one student, we'll have to do it systemically. We can't confine it to one student. As a court, then we have to be fair and we have to do it for the entire batch of students. There'll be more students, perhaps somebody more meritorious than your client also.
I have been vigilant in pursuing my rights, my lords.
Great. Sorry.
I did timely approach the High Court.
Thank you.
Grateful, my lords. Grateful.
May I please, Miss? Well, my lords, you've seen this spectrum. My lords, have seen the profession.
I know, but we can't now. The bar, so there's something called voluntary effort. The bar associations must now take a lead in addressing issues of mental health. Because, when we say lawyers, we'll be talking of lawyers all over the country. How do we assess issues of mental health in, say, some district court bar somewhere in the country?
That's certainly not I'm suggesting. Today,
create a platform to address mental health issues in the legal fraternity. Union of India will say that, look, how can you only do it for lawyers? What about chartered accountants? What about engineers? What about army personnel? What about doctors?
In case of certain professions, is already there, Manoj. Like in the medical education, IMA takes care of the doctors which are there. And in their education system, it's protected.
Not amenable to judicial parameters.
Well, I'm not. We are not deficit on. We are not deficit on the legislative scheme.
Thank you.
No request, Manoj. One small thing, Manoj. I can push this as a representation before the Bar Council of India. We have an Advocates Act which deals with the welfare of that.
Immediately do anyway. Despite the dismissal, you can always go there. You can
the only
dismissal of this petition shall not come in the way of the petitioner, following remedies before the appropriate fora.
May I request, my statement may be recorded to the effect that I will file a representation before the Bar Council. It's only a one statement will give a push, Malas. It's nobody's interest that we have young lawyers who are
appearing on behalf of the petitioner states that the petitioner is advised to move the Bar Council of India with an appropriate, to highlight the grievances which have been made in the present proceedings.
Very well.
The petitioner is dismissed as withdrawn.
Great.
Obliged.
9, none.
May I please, Lord?
No, 9, I'm on KV8, my lords.
My lords, this is an iconic restaurant, one of a kind in Hyderabad, center of Hyderabad. Cafe Bahar, my lords, where they have a recipe which is not even known to any other member other than the family itself. It has been running from 1970. Only time it ever closed was during the COVID lockdown.
4 years.
My lords, at this juncture, what has happened is a 14% partner wants a dissolution and moves for arbitration. 14%. We are 86% other petitioners. And the first petitioner has been running this from the time he was 14 years old. And he is today 45. He's been running this restaurant from then. He took it over. Now, my lords, the trial court, they move a section 9 for appointment of a receiver.
The trial court appointed you, the first petitioner.
And with various safeguards. What happens is, at the first stage, as an ad interim order, a learned district judge is appointed as a receiver. And it closes down in October. Under him, he says, I can't do it, and it closes down in October. We move and say, please reappoint me. I should continue as the trial court said. Now, the court has appointed an IRP, my lords. We're not a CIRP company.
14% share. Why don't you do this? Look, ultimately, we can treat this as any other matter and say interim order and this and that. Ultimately, both of you, the restaurant has acquired a degree of goodwill, I presume. Why don't you both sit down and one person buys out the other?
We are ready to do so, my lords. Whatever.
Either you buy them out or they buy you out.
In fact, it has a provision for retirement also. While it says it's at will, it also says for retirement.
When is this? Now the High Court has appointed, we are not going on into whether we should interfere in this matter. Because when the matter opens, we'll see what to do. But if it continues in the hands of an IRP, He will not be he will not be able to run a restaurant.
He's
What
already
is
said so, Manoj.
And he's now filed a memo in the High Court saying I'm unable to run it.
Says I can't.
And we've remained closed now for a month.
Far-fetched to expect the IRP to mix a cocktail, you know. So
that there is
so
a
the
secret
restaurant
sauce.
the restaurant will just go under.
My lord, that there is a secret sauce that needs to be known only to the family. My lord, is not a part of the proceedings. But two facts I must bring.
Absolutely.
The trial
which only the family knows.
my lord,
Why don't you do this? Your both sides are people of business. You are men of business. You want to save the restaurant, right? The restaurant has a goodwill. Putting the restaurant in the hands of somebody who doesn't know what running a restaurant is, people will stop coming to the restaurant. Why don't you both tell us some reasonable solution? Both of you tell us.
All I'm saying is, whatever safeguards they want to protect their interests, whatever safeguards they want.
We don't want to take sides between any of you here. Because if you have to decide it, we'll decide it in accordance with law and see whether we should at all interfere. But why don't you both tell us what the solution should be? Sit down together and find a solution.
My lords, number one, she's never been in the business, but surely has an interest of 14%.
What is your interest?
86%.
How many people are
Four of them.
Four of us have 86. She has 14. She's never been involved in the business.
Is she
Sister, related, all related. My lord,
You four are brothers? Or what?
Yes.
You're so you're all brothers, sisters.
We have one sister is on my side. We are 4 siblings. She is Manoj's one sibling.
Oh, so 3 brothers and 1 sister.
One sister.
And 1 sister.
And her 14%, we offered to buy her out because she's not been involved in the business. She's never been part of the business. We said, let's value it. She lives in Bangalore. She doesn't live in Hyderabad. She lives in Bangalore.
Well, just 2 or 3 facts.
We offered her 12.5 crores to, sorry.
Would you like to go to an arbitrator who can resolve this?
But in fact, this is
I'm
arising from an
very happy
arbitration
to do
request.
that, but meantime, we want to run, my lord.
I know. 9.
Absolutely.
Has the arbitrator been appointed?
No,
not at all.
Yes, no. Now, some stark facts. What happened was 86% wanted dissolution first. They suggest 3 names of an arbitrator. As a sister, I consent to the nomination given by them. The arbitrator appointed. Before the arbitrator, my lord, arbitrator says, all right, to pay the sister 1 lakh rupees per month. They don't come. His lordship, just can be 1 minute.
Who's the arbitrator?
Justice, my lord, his lordship, Justice Kodandram, has his lordship, earlier retired High Court judge, was appointed. Suggested by them, yes, lord, suggested by them, accepted by me. But I must tell your lordships a few more facts. My lord, before the arbitrator, consent award only 1 lakh per month to be paid to me. They don't pay for 5 months. My lord, then what they do is I file an application for receiver before the arbitrator in an ongoing arbitration proceeding saying that yes, my lord, they are not complying not only with the order.
Then what happened there?
My lord, lordship just grant me 1 minute, my lord. These are very important facts. Each of
Tell us what happened in that application.
Now what they do is, pending arbitration, my lord, they siphon off 4.3 crore rupees money.
This I take
strong objection. I'll place this.
Let's give him a
No, my lord, because they have,
Very much.
she took out a...
We don't have to hear this.
Yes, please.
Let him have his point in court.
Just 2 minutes, my lord, I'll be able to sum up. My lord, pending the arbitration, when they were not paying the monies and not rendering proper accounts, I filed an application for appointment of a receiver. After the receiver application has been filed, they siphon off 4.3 crore rupees and I'll be able to show it from the record. Their documents filed. After 4.3 crores is siphoned off, they withdraw their claim from the arbitration saying that now we do not want dissolution. I file a counter claim that I want dissolution because a partnership at will. My lord, the arbitrator says no, since the claimant is withdrawing, it's left open for you to work out your remedies. I then issue a dissolution notice. We go to the Section 9 court asking for appointment of a receiver. Receiver appointed, my lord, order not in challenge. What your lordships are hearing today is not the order appointing receiver. Receiver order becomes final. My lord, the court records it's a partnership at will. The arbitration award did not make it a continuing partnership. One of the partners can dissolve it. Dissolved, therefore it's at will. If it's dissolved, receiver ought to be normally appointed. They said it must be the person who's conducting the business. My lord, the trial court was sensitive to appoint them as the receiver. For a period of 6 months, my lord, they play, my lord, ducks and drakes with the court. Contempt case filed by us. Now what happens is, in the meantime, we file an appeal before the High Court saying that though they are appointed, they are not discharging their duties properly. They are conducting the business insidiously. But before the High Court, they consent. But first, appointment of receiver not challenged. Before the High Court under interim order.
What? They consent to what?
Consent saying that yes, let a neutral person, a retired district judge be appointed. So a retired district judge is appointed by consent, my lord, by the High Court. After the retired district judge is appointed and the district judge goes to take charge, since these persons have been conducting the business, they make all 100 employees not report to duty. They want to frustrate the district judge. The district judge has submitted a report before the High Court in a sealed cover. If your lordships were to summon the sealed cover will show how they systematically try to frustrate the appointment of a receiver to which they consented. Then High Court in this final hearing takes a decision that they have not been conducting the business fairly. They are guilty of, the court does not record a finding, but I'll be able to show to your lordships. It notes our contention that 4.3 crores has been diverted. Before the trial court, they say, yes, we diverted.
Now that we got the overall, we're just trying to find some business-like solution to the matter, not an IRP.
Correct.
Tell us one thing. You live in Bangalore.
Yes.
Are you willing to be a receiver?
Hyderabad. We live in Hyderabad.
Can you act as a receiver?
They would say that I have not had prior experience, but I'm fully willing to act as a receiver. Your lordships can appoint some other person to assist us also, and we will fairly report everything to the court.
On the other hand, look, yes, we are also conscious of the fact that they are 86%, you are 14%. Suppose, for instance, we are not finding don't react immediately. Suppose we give them an opportunity to act as the agents of the receiver, subject to stringent safeguards that we appoint, say, a chartered accountant, all right? A chartered accountant or a retired judge, but preferably a chartered accountant both of you have faith in, who will scrutinize the accounts which are prepared by them on a weekly basis, fortnightly basis, whatever you feel is appropriate, to ensure that they don't siphon off any funds from here and they duly account for whatever is being carried out. One way of looking at it is, look, you have given a dissolution notice, there has to be a lock on the door. But that I'm not sure if it will protect both your interests.
But I respectfully agree. I may just make one or two submissions. What happens now, my lord, if it has to go up towards resolution, they can always buy out. One partner can buy out the other partner. There's no difficulty. My lord, the real crux will arise.
Tell us one
in the arbitration.
1 second. Tell us one thing. We can try and put an end to it. Suppose we say they're 86%. There are 3 brothers and 1 sister on one side. You have 1 sister on the other side. No point in your fighting for the next 10 years on this and wasting your happiness on this. What if we say that, look, we will give them the first opportunity to buy you out, right? You both tell us the name of a valuer. If you want a retired judge, we can name a retired judge. Ideally, you tell us the name of a valuer, a chartered accountant, in which both of you have confidence, all right? In which case, that chartered accountant they'll value the business, the assets, the goodwill. On that basis, quantify your 14% after excluding if there are any tax liabilities. And they will buy you out at that. If they don't buy you out and pay money within, say, 14 days of the determination, you buy them out, an opportunity to buy them out.
Yes, two submissions, my lord, because what would happen, my lord, if they would have the preemptive right where it might work to my disadvantage, I'm only placing it for lordship.
All right, the other way you can do it.
Yes, ma'am.
Yes, the other way you can do it. Once the valuation is done, you give bids and steel cover to the valuer, and whoever gives a higher bid will get the place if you want it that way.
Not only one submission, but this is a difficulty a value
for both of you.
My lord, I quite see, my lord, why your lordships are indicating this. Not I completely respectfully agree. But
Any other submission, you are both people of business. You tell us if there's a better solution, we'll adopt it. We have no difficulty.
But only one difficulty.
I'm totally with your lordship.
One difficulty.
One or the other, they can't. Obviously, my lord, this is a business which is a flourishing business. The sad part is someone from the panel of IRP has been appointed in a flourishing business. We are 86%. Any fair price we'll buy.
What we can do is, in the meantime, suppose we appoint a valuer. We appoint a valuer who will value the business assets, goodwill, etc. Assess the liabilities and then decide the value of the business.
May make one submission.
In the meantime, just a second. In the meantime, you don't want the restaurant to be closed. Okay. We can allow them to run the restaurant in the meantime, subject to a stringent safeguard that they will submit accounts to the chartered accountant.
One submission I have.
Yes.
So only to take what fell from this honorable court further. But I'm not contradicting it. My lord, what will happen is there are two important components of this business that need to be valued. One is, my lord, the immovable property, easy job. They'll be able to value it. The other is the goodwill of the business, my lord, because this particular restaurant generates a huge amount of money and mostly in cash. So what happens is, my lord, if a person is kept outside, my lord, the goodwill valuation comes down. My lord, I'm making one respectful submission for your lordship's consideration without prejudice.
Is there a bar or is there a bar?
No, my lord, there's no bar.
There's no bar.
Yeah. But my lord, it's one of the most famous.
But it's famous for its biryani.
I go to Hyderabad.
The biryani, it's famous for its biryani, which neither my lord, the Chief Justice, nor I have any idea of. but
if any of my other lords, my lord, are partaking non-vegetarian food, I must strongly recommend that this biryani your lordship should.
Unfortunately, this IRP also claims to be a vegetarian.
One submission.
Who's asked to run it?
Just for ensuring, my lord, that there's a proper accounting of the money that is coming. The restaurant has to open, my lord. I cannot object against that. Lord, I am suggesting, lordships may kindly appoint joint receiver. One will be, my lord, them conducting the business as. I'm therefore making a submission, my lord, that may find.
Tell us what is the suggestion.
My lord, if a joint receiver is to be appointed, which is, my lord, any one person that your lordships may appoint, RP, any other person, my lord, as the receiver, them as the other receiver. So joint receivership, what happens, my lord, is then every rupee, every money that comes in will be accounted. They can't have an objection to your lordships appointing a person who will conduct it jointly with them as the receiver. Earlier, when they were appointed as the sole receiver, my lord, they have actually conducted actions to show that they were not reporting fairly. Now, this would mean, my lord, that the valuations would come correctly.
For the tax returns, the net income shown.
Net income?
30 crores a year.
30 crores a year.
In excess of 30 crores.
In excess of 30 crores.
Turnover is 30 crores.
Turnover.
Net income.
Just one standalone restaurant.
It's just one restaurant.
It's not a chain.
And my lords,
It's
it's a very quaint cafe, my lords. It's the old world style.
But I'm told.
Wooden chairs.
But I'm
That
told.
kind of cafe.
These figures are on record. Returns that are filed are in relation to.
My lords, they must also say they took out 1 crore 25 lakhs as their share. 2 years ago, they've taken out 1 crore and 25.
Whatever is reported, subject to further proof, I'll be able to place for your lordships. There is an under-reporting of income because whatever is QR code scanned, UPI payments, whatever are Swiggy deliveries constitute the majority of the accounted sales.
We appoint you as a receiver.
All the cash.
How much will you be willing to deposit as security?
Deposit as security?
On a monthly basis.
On a monthly basis.
2 crores? Well, we'll let this matter valuation be done. Meantime, we'll deposit 2 crores as security.
A month.
A month.
Not a month. They don't have 2 crores a month. 2 crores we'll deposit as a security. Let the valuation be done within 4 weeks or 8 weeks and we can conclude the matter. My lord, we are saying here and now, whatever value of whoever you
will deposit 2 crores 10 lakhs, my lord. And lordships may record, permit us to act as a receiver. That is what they say. They should be fair to your lordships. Lord, I'm making a very fair suggestion.
How much do you think they should be asked to deposit?
May I make one?
Tell us, you give us a ballpark figure.
I arrived at 2 crores based on 30 crores. I just arrived.
2 crores, just like that.
Lord, may I make one?
People were saying 2 crores per month.
No, he misunderstood.
More fair.
It doesn't make that money. This is a place, my lords, in Hyderabad town itself. Township, there's a little restaurant.
What is fair?
Lord, I'll take instructions because my lord.
Give us a ballpark figure now. Whose time here? We'll pass an order right away.
My lord, we are taking instructions because the clients are not here. But just one submission, if it appeals to my lords. But we want.
You are saying joint receiver.
Yes.
It practically won't work, my lords. How are we to
they
run
will
it?
run the business. They'll only manage
the whole
the
problem
accounts.
is one receiver closed down. The restaurant closed down. The second receiver says, I can't run it.
Don't we do this?
Let them run the business.
We will not ask you or we will not ask them how much security they should furnish.
Correct.
We'll fix the security. All right. Now, once we fix the security for them to run as a receiver, instead of a joint receiver, what we'll do is we will appoint a chartered accountant to whom they will submit weekly accounts.
Daily, it's cash. Mostly is cash. There are many times that I have paid in cash.
That chartered accountant will lose his own practice if we ask him to do it there.
But the only thing is this, my lord, because which is why
accountant have to depute somebody.
Yes, my lord. And your lordships may fix them, my lord. We are willing to bear half the cost. Lordships may fix some reasonable remuneration. Let somebody be there. Let them completely be understanding what the accounts are. Let them run the business.
No allegation that cash is
Do you both
taken.
do you have any faith in a chartered accountant? Joint name you can give us?
A chartered accountant to take our accounts even on a daily basis, we have no problem.
Fair enough, but can you both not give us at least as counsel? Give us the name of a chartered accountant in Hyderabad.
I can sit with them and give some names.
Just tell us right away.
Chartered accountant.
Who's a good chartered accountant? Anyone, you name them.
Who's your Chatterjee?
Ashish Agarwal.
He says he uses.
Only one.
That's his.
My lord, there are two or three. My lord, I will.
My lord, may I say
Cleaners
this?
will be able to give
This
a name.
statement of money being taken out and cash being received is being made for the first time orally before your lordships. This has not been their quarrel. Their quarrel was I took out 3 crores and it's been recorded that they got their share of 1.25 crores at the same time.
Contempt
At the same
specific-
time, we both took out shares from the partnership.
The contempt case filed specifically alleges for the 6 months they acted as receiver. This is what they have done. My lord, for full the receiver and they did not report fairly to the court. That's a contempt case filed. Not for the first
Not
time
even
sitting
notice
here.
issued.
Notice issued, sir.
Restaurant non-functioning doesn't help them, my lords. Doesn't help.
My lords, and if anything, they have 14%.
2 people have tried to run it and failed.
Record your terms, that will record terms to the effect that all of you, you will, that we will appoint, there will be a valuer appointed,
My lords.
all right, to value their 14% share, all right. After the valuer values the share, you will have the first right of refusal. You will offer them that their valuation and pay it within a period of 2 weeks. Failing your paying it within a period of 2 weeks, they will give you that offer for your 86%.
My lords.
Can you record these terms and come back by the evening today by 3:30?
My lords may make it an order of court by consent.
Just ask for this one.
My lords may make it
Even
an
for
order
the
of court
valuer-
by consent.
Yes.
Even for the valuer to value the goodwill, he will need to know the income. My lord, the incomes that are reported, my lord, if there is a joint receiver, I'm saying let them run the business, let some other
No,
person be there to
valuer is
report.
still the valuation
My learned
today.
friend, just bear with me. But I'm making a submission which they cannot have an objection to.
Valuation
my
is
respectful
valuation
submission.
today.
My lord, let them run the business. Let some chartered accountant firm, my lord, look at that business for the purpose of finances. After 1 month, my lord, valuation can be done.
Lokesh Gupta, E&Y.
Understand who's a partner of E&Y, who's meant to be quite a,
Originally from Hyderabad.
who was originally from Hyderabad. The point, my lords, is he'll value it as on today. To safeguard his interest in the meantime, when I run it, I'll deposit an amount.
Will be all right with you? Or what we'll do is we'll dictate the order. Before we rise, give us either by consent the name of a chartered accountant.
My lord, any name your lordships are.
We don't know, because neither of us belongs to Hyderabad. We just took the name of Mr. Lokesh Gupta. If it's
Is
acceptable
he
to you.
in Hyderabad or in Bombay?
He's in Bombay. But
Then no, give me someone in
Ashish
Hyderabad.
Agarwal.
Ashish Agarwal is the name.
Has to be somebody in get somebody from Hyderabad.
Hyderabad.
Agarwal, Ashish.
He's his own.
Otherwise, then we'll have to ask one of our colleagues from Hyderabad to give us a name.
One
We'll
of
do
our
that.
colleagues from Hyderabad, Manoj, would be I.
So we will just see if this is agreeable. We'll dictate the order. The petitioners, the dispute in the present case relates to the affairs of a partnership firm which is conducting a restaurant by the name of Cafe Bahar and Restaurant in Hyderabad since 1999.
73.
Don't say since, just say in Hyderabad. Full stop. The firm was reconstituted by a deed dated 1 October 2020, correct?
Correct.
Full stop. The first respondent, full stop. How many petitioners you said? 4.
4.
The 4 petitioners, into brackets, comprising of 3 brothers and a
Actually,
sister.
2 brothers and 2 sisters.
Comprising of 2 brothers and 2 sisters, bracket, and the respondent are siblings. Full stop. The petitioners have an 86% share in the profits.
In the firm, in the partnership firm.
They have an 86% share in the partnership. Full stop. The respondent has a 14% share. Full stop. Is it respondent or first respondent?
Sole respondent.
It says and others, that's why.
Oh, sorry, mine doesn't.
Sole respondent.
Sole respondent. I just checked it. 22.
Initially, the petitioners 1 to 3 initiated arbitration proceedings for dissolution. Their arbitration proceedings were for dissolution. And for dissolution and accounts?
Yes, ma'am.
For dissolution and accounts. The arbitrator passed an award on 22 September 2023, permitting the withdrawal of the claims, correct?
That's correct.
Good stop. The first respondent issued a notice calling upon the petitioners to render accounts and for distribution of the assets of the firm. Full stop. An application was filed under Section 9 of the Arbitration and Conciliation Act for the appointment of a receiver. Full stop. The application was allowed and a receiver has been appointed.
Correct. By subsequent order, receiver appointed.
Yeah, the application was allowed. Full stop. The commercial court passed an order in the first instance by which the first petitioner, who is the managing partner of the firm, was appointed as receiver. Full stop. In an appeal under Section 37 of the Arbitration and Conciliation Act 1996, the High Court set aside the order of the commercial court and has directed Shri Dantu Indu Shekhar, right? Dantu Indu Shekhar, brief se naam le lo, resolution professional in the panel of the Insolvency and Bankruptcy Board of India.
That's correct.
To be appointed as receiver to manage the affairs of the firm.
Who has since filed a memo saying he cannot do it.
That's all right. Yes. The court has been apprised of the fact that the receiver, that the person appointed as a receiver has since expressed his unwillingness to, correct?
Because of
unwillingness to act as such. Next. At this stage, it is an admitted position before the court that while the petitioners have an 86% share in the partnership, the first respondent has a 14% share. Full stop. The Mr. Ariyama Sundaram, Learned Senior Counsel, and Mr. Sibal, appearing on behalf of the petitioners on the one hand. We have heard naam those side. Learned Senior Counsel on both the sides. Just one second. Don't lose sight of the order in case there's something you have to correct us. Learned Senior Counsel appearing on both the sides are fairly agreed that the affairs of the restaurant, that the proper conduct of the affairs of the restaurant would not be subserved by appointing someone unrelated to the business as a receiver, because that may only result in a loss of the goodwill of the business. Correct? Can we say that? Or don't say learned counsel apna kar do. That is, I think, it's common sense actually. So, hence, during the course of the hearing, we have suggested, during the course of the hearing, it has been agreed that in order to resolve the dispute between the parties finally, a valuer may be appointed so that the business of the partnership can be valued inclusive of its assets, goodwill, and assets of all nature, or inclusive of all assets, goodwill, and the liabilities. Stop. Once the net valuation is arrived at, it has been agreed that the petitioners shall have the first right of refusal and offer to the first respondent an amount equivalent to her share of 14% in the partnership within a period of 2 weeks of the date of valuation. Full stop. In the event that the petitioners fail to do so, then the first respondent would have the right to purchase the 86% share of the petitioners on the basis of the valuation fixed by the common valuer, by the valuer. Full stop. To effectuate the above purpose, the work of valuation shall stand entrusted to anybody's name.
Who's valuer?
But we'll give some leading names, but I'll just.
All right.
There's a leader and company.
Why don't you do this? both of you.
I think both of us should be on the name.
As senior counsel, you give us one name. Don't look at the client. Give us one name. Mr. So and so, Mrs. So and so shall stand appointed as valuers for that purpose. Then next you say, pending the valuer is requested to carry out the work of valuation expeditiously and within and on or before 31 December 2024. Full stop. Next. Pending the permitted to resume the business of the restaurant. Full stop. Now the arbitrator is already appointed?
No, my lord, section 11.
Not yet appointed, but if, my lords, the matter is going to be sorted out by the valuation, it need never go to arbitration. The whole matter is over.
Request.
No, we were thinking that we can appoint someone to implement this order.
Yes.
Very well.
But in fact, your lordship.
My lord, earlier your lordships had appointed, not.
Should we appoint Justice Raghuram?
Absolutely.
Yeah, Mr. Sundaram, will you appoint Justice Raghuram, Justice G. Raghuram, by consent of the parties, Mr. Justice Goda Raghuram, former judge of the High Court of Andhra Pradesh, is appointed as sole arbitrator under the Arbitration and Conciliation Act 1996. Full stop. Initially, in the event that the parties are able to settle the dispute in the terms indicated above, it would not be necessary to proceed with the arbitration. However, parties would be at liberty to apply before the arbitrator for giving effect to the terms, the above terms which have been agreed upon in court, so that a final award can be passed for implementing the understanding. Right. So because we don't want it to come back.
Right away, Justice Raghuraman is also vegetarian.
Two submissions.
Yes.
Lordships have completed. I'm sorry. One, my lord, since your lordships are appointing a valuer, let the valuer have an active, my lord, evaluation of the accounts, because anyway he has to conduct the valuation. My lord, it will only help. My lord, second thing.
What do you mean by active valuation of the?
Which means, my lord, I'm only suggesting that all the monies that are received on a day-to-day basis can be reported to the valuer.
The petitioners shall maintain accounts and shall furnish weekly accounts to the valuer so as to facilitate the work of valuation. Right?
My lords, please.
My lord, I am only reiterating my request, my lord. If somebody from the valuer's team can be there to look at the accounts,
the valuers would be at liberty to depute anyone associated with their firm to the premises of the restaurant so as to take a daily stock of the accounts of the firm.
My lords, please.
That's
Lordship.
My lord, one last caveat, my lord, subject to what your lordships would say.
Now, what we'll do is, I'll just tell the court master to type the order
Yes.
To give you both a printout, since we have dictated it as a consent order, any change you want, just come back at 3:30.
But only one request. But only one
request. If anyone would like to just come here, or you can call them to the courtmaster's room, or wherever, what will you do? You will show them. You ask, like anybody, to go to the courtmaster's room, he'll show you the order on the screen. Any correction or anything, just tell us at 3:30.
Yes.
Otherwise, then IAs, MAs, this and that,
But only one request. My learned friends are still here. My lord, once the valuation comes, your lordships, my lord, because they are 86%, they have been given the first right of purchasing, my lord, no difficulty. But suppose, my lord, if we are ready to pay a higher valuation and ready to buy them, it should not be that the valuation should be binding on me.
Well, it can't be 86 and 14. It can't. It's
No,
not
no,
fair, my lords. That we get into a bidding
higher
warfare. Because I don't want them to bring in a third party.
No, it has to be
He
fair
can't
to both.
then start bringing in a third party to, that will ruin the whole thing. It's been a family business. Manoj, if he goes into this warfare of that, then he brings in a third party. Whereas it's a family business. We're proud of it.
But if it is valued at 100 crores, I will say
Manoj,
we
give
give
them-
150 crores and pay 86% on 150 crores.
It's a family business.
Which I have managed since the age of 14.
I think it's a family business. Let the business stay in the family. What will happen is, suppose we start bidding, then some third party will just
Only between us, only between us.
It's not really in that sense desirable that a third party comes in. It's a business which is run by the parents.
And my lords, to
the death of the parents, both of you have run it.
And the extent that the recipe is only known to the members of the family. That's why we don't have franchising. We haven't even give the franchising to anyone.
My submission was between us, there should be valuation.
From the time he's 14,
It
he's
should
not
not be-
running this business.
We thought of it. In fact, we thought that your suggestions is attractive. The only problem is if we allow bidding, then we can't prevent, say, for instance, your client. Suppose your client is financed by somebody else who says, look, we'll match their offer and we'll give a much higher, then the restaurant will go out of the family, It's better that the restaurant stays in the family. I mean, we're not looking at it in a commercial sense, but in the family, it's a family restaurant. It's in the family for such a long time. So either if they don't buy you out within 2 weeks, we have not given them a long rope, 2 weeks for the valuation. Then you buy them out at 86.
Please look at one concern. One concern. My lord, if the historical numbers, my lord, lordships are well aware, lordships can take judicial notice. My lord, in many of these unorganized businesses, my lord, what happens is a lot of cash income is not revealed.
Obviously, it's all cash.
Yes, lordships are there.
Yes.
Now, what happens is if the valuations are to be made on these historical accounts that have been filed, the valuation will obviously be lower than the valuation the business actually deserves. Then what happens if the valuation comes at 50 crores?
What
They will say,
do
we'll
is,
pay you
we
7
will say
crores.
the current value. We'll say the current value. And we have said that he will look at the accounts on a daily basis to see what the generation is.
But at least if your lordships could enter those caveats.
We'll just say that. The current valuation, Bolo. Just have a look at the order in the courtmaster's room. Is there any correction? Come back at 3:30. We'll just try to bring some peace. Otherwise they'll just they'll fight for the next 10 years and the business will get wiped out.
Yes, but only one final request. But even when they were appointed as receiver by the trial court, but there are a set of conditions that were imposed. They are there in the order, which I'll give the page number, my lord. If
the petitioner shall abide by all the conditions that have been imposed by the trial court for the appointment of in connection with the appointment of the receiver.
My lord, I'm depositing 5 crore in addition.
In addition, so that we don't come back with a clarification petition for your lordships.
The amount of rupees, 5 crores. The amount of rupees 5 crores shall be deposited within we have said within a period of 1 week.
Your lordship said 2.5 crores in 1 week, and 2.5 crores in 4 weeks.
वो बता दिया ना, लिखा ना आपने, before the High Court of Telangana.
My lords, please.
My lord, in relation to this, I'm just flagging one issue. Total amount lying in the partnership account was 7 crores. They have taken 4.3 crores. 3 crores is in the partnership account. This amount should not come from the partnership money. It cannot be partnership money.
The amount of rupees 5 crores shall be deposited, shall not be taken from the partnership account, but shall be deposited by the first petitioner from his own funds, because not from the partnership account.
Only to save, my lord, any
Petitioners.
Petitioners.
4 petitioners.
Only to save us coming back to your lordships for any smaller issues. Lordships may kindly grant the liberty, my lord, that if in the working out of this order, if we have any difficulties, we can approach the arbitrator appointed by lordships.
That's already there.
Yeah. I'm hoping by 31st December it will
The event
all be over.
any difficulties arise in the implementation of the present order, or if any consequential directions are required to be issued, parties would be at liberty to move the arbitrator. The learned sole arbitrator would be at liberty to issue directions under Section 17 of the Arbitration and Conciliation Act 1996.
My lords.
Where everybody doesn't have to run to the Supreme Court. That's a fair suggestion. Yes. This is a fair, balanced order, I think. You can get the restaurant, but you have to.
Name, I think my lord might know, my lord, I'm suggesting Anandam and Company, which is a leading firm in Chennai and Hyderabad. I don't know the names. They're not my chartered account.
Give me 5 minutes.
Anandam and Company.
I'll just check it out, Manoj.
And just let us know so that the court master.
I shall. I'll just. Manoj.
Right.
Who's Anandam?
Please, Manoj. Item 10, the petitioner is seeking admission under the sports category for medical seats in Karnataka. I'm somewhat similarly.
Dated 16th March, and it will be notified by KEA on his website before the last date for submission of the application.
Please, Manoj. It was notified on 16th of March. The important aspect is my applications for
round commenced on 1 September, second round on 18th September.
And my writ is filed, my lords, on 11th September.
That is too late, because after the second round was started, it is only at the stage of mop-up round of counselling that petitioner approached the
That finding, my lord, with my humble submission is incorrect. The first round had indeed concluded. Before the second round had started, I had filed my writ.
The amendment was done in March.
But the seats were still vacant, my lords, when I had filed my writ, and there was an interim order also passed in my favour. One seat was specifically kept aside, my lords.
11.
My lords, in item 11, I appear for the state. The matter was mentioned day before yesterday. I had made this request, my lords. Notice is on 2110. I need time to file a counter, my lords. It's a commercial dispute, my lords.
All right, let him file.
My lords, so there was a reason why I had in fact mentioned day before yesterday, my lords. He had moved an application. Now, what had happened was for 2 years, the arbitration went on.
His review petition was allowed, is it?
Yes.
On 4th of October, by 9th, they went ahead and took unfair advantage. I had a Section 17 protection for BG. They went ahead despite my informing them that don't go for BG. I've already filed the SLP. They encashed the BG.
They went for?
Well, they went for encashment of BG, though I had informed SLP has already been filed. My interim relief was for stay of encashment. Now, I know this is a different predicament, but my submission is this. My lord,
the BGs have been cashed on 9-10. Now they seek mandatory injunction.
9th is when I had filed the SLP. The problem is this. I wouldn't have trouble. The problem is this, my lords. I have a loan of 32 crores. This is a 15 crore BG, which they have now taken from my bank account. It is already gone. This is bound to go NP. I'm running real estate projects about home allottees are there. The entire thing will go for NP. I would not live to fight for on the day. So my submission, my lordship's consideration, I'm willing to revive the BG provided they give me the money. They'll be fully secured with the BG anyway. It is not that they're not secured.
Yes.
So my lords, I would give the BG, let them deposit that amount. I'll take it and again give the BG back. The BG was alive till January 25. They were fully secured. There was no reason to immediately state for within 4 days of the order to encash the BG. So anyway, they'll be secured, my lords. There'll no prejudice cost. I am seriously prejudiced today. Today, if I go to NTA...
The High Court says that since only the engineer-in-chief could be an arbitrator.
Yes. My lords.
Therefore, the High Court says there can't be any arbitration because he's disqualified.
It was, my lords.
But therefore, they gave you liberty to move the civil court. That's
what had happened. So what happened was, on the first day of Section 11, they did not object for appointment. On the first day before the learned arbitrator,
and this is Hemant Gupta.
Yes. Before the learned arbitrator also, they gave their consent to proceed. They filed a counter claim.
You're absolutely
The evidence is towards the end. And now at this stage, the review petition has been reversed. And 17 was all through in my favor. They never challenged the 17 order. There was a BG encashment protection in my favor.
Ultimately, just 2 former judges of our court have been appointed as arbitrators.
No, my lords, so there are...
What is the stage of the evidence?
So, my lords, evidence had commenced. The facts have been concealed from this court are that when the review petitions were filed, an undertaking was given by the petitioner that they will not further the matters before the arbitration. That undertaking was breached. 5th of January 2024, a stay order is passed. All this is concealed in these proceedings.
So stay order where?
Before the High Court, my lords, both the arbitration proceedings. On 5th January 24, it is concealed. Now the order of 4/10/2024 is passed, recalling the orders of appointment of arbitrators on the ground, my lords, that 1, the arbitration clause did not exist as it is worded. 2 and 3, my lords, that there is no section 20.
So 2 and 3 what?
That there is no section 21 notice, my lords, at all. And it is an admitted position. And my lords, I'll take my lords to that.
They never gave a section 21.
They never gave it, and it is admitted, my lords. And they say, my lords, in their reply to the civil review that they filed before the High Court, that the order was dictated in inside chambers, my lords, not in open court, and it is a copy-pasted order. And we don't agree to the submissions recorded on our part in that order. It's very strange, my lords, and therefore I need to file a reply, place these documents on record. And there is absolutely no prejudice. What my learned friend has said about the loan, etc., none of it is pleaded.
The prejudice is really of today. The state would have no prejudice at all in case just my BG is revived. Today, my lords, I'm likely to go for NPA. There's a serious problem I'm already facing. I've already defaulted in my first month of payment of EMI. My lords, eventually it will go for NPA, my lords. I am running a real estate building of 1,000 allottees. That will also go in NPA. How is state prejudiced today if just a BG is restored, my lords? That is all I'm asking for. They are fully secured.
Huge relief because they've encashed the guarantee, Mr. Baruka.
But within those 4 days, 4th of October is the High Court order. 9th I move. I write them a letter. The moment I write a letter, they immediately encash. In my interim relief before SLP, my lords, I have written, kindly grant me stay for encashment. So it was on that day, at least when I filed the SLP, BG was not encashed. It was encashed the moment they got to know SLP has been filed. There was no hurry. The BGs are alive till January 2025. Even today also, my lords, I'll maintain the same terms conditions. My lords, the only problem is today I will go on NPA. My creditors, the bank loan, etc., they will initiate NCLT proceedings against me. The other real estate project going in Gurgaon, that will then go down with those 1,000 allottees. State would have no trouble if there is another BG in cash, securing them.
None of these
that is my only concern today, my lords.
None of these facts are pleaded, nor any document shown to show any.
You know, the High Court has reversed the order for valid reasons, actually.
Yes, my lords.
High Court has reversed, the Honorable High Court has reversed without realizing that specific consent before the learned arbitrator that we have no objection in the appointment. It is a specific, my lords, kindly just see page 469. And they filed a counterclaim, my lords, of 350 crores. Page 469, my lords, may I just read 3 lines of 469, the first procedural order of the learned arbitrator, page 469. And I leave at it, my lords.
Yes.
There is a consent, kindly see above paragraph 3. Both the parties as well as their counsel stated that they have no objection towards my appointment as the sole arbitrator of the arbitral tribunal to act as arbitrator as ordered by Honorable Patna High Court by order dated 1/2/2023. After that, they filed a counterclaim of 350 crores. Evidence is at the respondent stage cross-examination. My evidence is over. And then at this stage, my lords, the Honorable High Court, in a review petition, reviews section 11 order and recalls the order, my lords. In fact, my lords, in my submission, my lords, that will another question of law will arise whether review petitions at all maintainable in section 11. But at this present stage, my lords, just to safeguard myself and also equally safeguard the state, the bank guarantee can be restored. The amount can be given back. I will immediately restore the bank guarantee. They are fully secure. Tomorrow, if they succeed in the arbitration, they have the bank guarantee anyway. How does the state prejudice in that matter, my lords?
My lords,
today, I'll be seriously prejudiced, my lords. If today the NPA goes, I would not live to fight this matter.
My lords, no
For
fact.
2 years, there was a section 17 protection in my favor.
Invoked arbitration. There was no section 21.
There's no section 21, my lords. And there's a stay by the High Court in the review.
I think not a case.
That is concealed. I'm grateful, my lords. My lords, liberty to file a counter, my lords.
Where?
File a counter, my lords.
Yeah.
Oh, I'm sorry, my lords, dismiss them.
Yes.
I'm so sorry, my lord. I'm so sorry. Grateful, my lord.
Please, your lordship.
Yes.
Item 12, my lords, I am for commission, IPLM.
Yes.
Item 12.1 is another appeal, my lords, and 12.2 is another appeal. So, my lords, item 12 is appeal against April's order.
Yes.
Whereby, my lords, at the truing up stage, we denied the claim of erstwhile R infra, my lords.
Yes.
Which is R1 in the appeal, now probably they have moved an application for their deletion. R2, sorry.
R1 is without.
R2, sorry.
R1 is without.
AIPL, yes, yes. I stand corrected. R2, my lords. R2 and R1.
How long will this matter take?
Well, it will
There
need
is,
some
according
time.
to us, no substantial question of law.
My lords, on that I can answer, my lords.
How long, Mr. Rumta, will you take?
My lords, if it has to be, I mean, he is raising a preliminary objection. If on preliminary,
lords, may
about 10-15 minutes.
How long would you take on apart from the preliminary objection? What is the preliminary objection, Mr.
There is no substantial question of law under section 125. Because the tariff has been, it's a tariff determination, my lord. All that the tribunal has done is, I got cost for unit 2. For unit 1, I have been given same as unit, what was given for unit 2 has been given for unit 1. And the finding is
fuel costs.
Landed fuel costs. It's actually, my lord, in terms of the regulation. I am only asking for what is as per the regulation. They have tried to give it a color.
What do you have to say, Mr. Rumta?
On this. My lords, yes. On question of law, my lords.
Yes. What is
there are 3 substantial questions of law.
Yes.
1.
Tell us just one.
So the first one, my lords, is this. That whether at the truing up stage, we can give a go-by to the principles of determination of the tariff, not only provisional, but final tariff. That is the first question of law, my lords. In this case, my lords, the final tariff was determined. First, provisional tariff was determined. Then final tariff was determined on their application, on the basis of their own projections, my lords. So, now at the stage of truing up, my lords, they have come up.
Take a little time.
My lords, may I just make a submission?
I only say 2 things. Of course, my contention is that all along, my lords, we have gone under the tariff regulation. They say it is changing of the methodology. Their own order said that it will be under the regulation. You will get fuel cost as per regulation 49. That's all I've got. That's all that the tribunal has fashioned that relief. And the finding of fact in my favor is that the not getting that fuel supply agreement is not on account of any fault of mine. I had gone right up till the end, till the very last stage, and the government didn't give it to me. It's not my fault. On account of the amendment of the coal development policy. So, and additionally, up till that stage, they approved the PPAs. So to say now, my lord, that I should not get landed fuel costs is very unfair. Because what has happened with passage of time, my lord, now this is an insolvency. I am appearing, my lord, as the IRP before this honorable court, my lord, because to save the interests of the generator. And the difficulty is this, my lord, on account of these 2 proceedings, I just want to mention. There was a petition for midterm review filed before them 6 years ago. They heard, they reserved, till today judgment not pronounced, constitution of the commission changed, saying appeal is pending before this honorable court. Let them implement this order, my lord. Your lordships have never stayed, my lord, tariff orders. The order may be implemented, my lord. Whatever will happen, this appeal will happen. But the pendency of this appeal should not come in the way of implementation of this order.
My lords, may I just make a submission?
That clarification, my lord, why should they
In 12.2.
We heard it last time.
Because lords, in other fora, they are saying there is an effective stay, etc.
My lords, may I make a submission in 12.2?
My lords, in
12.2,
they have filed
your lordship,
like 13.
Your lordship, may I just make a submission in 12.2?
Please clarify.
No, my lord, kindly
Lordship, may I just make a submission in 12.2?
Kindly hear me on that.
Sorry?
Kindly hear me on that, my lords.
We have not stayed it for the last
No, my lords.
year. You think we are going to stay it now?
My lords.
We didn't stay it. We heard this when Justice Seema Kohli, which was Justice Pardiwala.
No,
November 22.
Not at that stage of, not on the stay, my lords. Kindly on the stay, hear me out, my lords.
But we
My
are
lords,
not
what
stayed. We
happened?
have not stayed it since 2022. We are not going to stay it now. Let them execute the order.
I am not, my lord, kindly give me 2 minutes only, my lords. My lords, have my IA, my lords.
I'll let you argue your appeal. Then you'll first see if there
My
is-
lords, may I just make a submission in 12.2? I have instruction.
Yes, my lords.
So we don't want to spend the same time in the IA and the appeal. Tell us in 5 minutes what the appeal is about. Tell us what the appeal is about.
My lords, the appeal is, my lords, the R1 and R2. R1 is the generator, R2 is the is the discom, my lords. R1 and R2 are sister concerns, my lords. R1 had 2 units, my lords. Unit 1 was admittedly captive power plant, which is not authorized to sell power to third party. Unit number 2 was IPP. Independent IPP, my lords.
What is IPP?
Independent power plant, which is authorized to sell the power generated by it
To anybody.
to the third party,
Right.
to anyone. Independent power producer, they are called. Now, my lords, since respondent number 1 and 2 were sister concerns, my lords,
All right.
they first approached the commission for approval of a PPA for supply of power from unit 1 and 2 both, by R1 to R2. Now, we declined. We said unit number 2 in the initial stages. We said unit number 2 is IPP, therefore we allow. But unit number 1 we don't allow. So you have separate PPA and come for separately for each of the units, 2 units.
Then what happened?
Then, my lords, they ultimately came up with another PPA in which they again approached us with combined, my lords, unit 1 and 2 with the amendment to the original PPA, saying that we will obtain the conversion of unit 1 from CPP to IPP. And on that basis, my lords, kindly have the PPA for a minute.
Just tell us the matter here.
In PPA, my lords, therefore, in clause 4 in the warranties by VIPL, respondent number 1, my lords, in the warranties it was clearly stipulated that within a period of 10 months, they will have fuel supply agreement for unit 1. And on that basis, on the basis of 100% domestic coal linkage, my lords, the PPA was approved in principle.
For unit 1?
For unit 1 and 2 both.
When was that approved?
Unit 2 was not a problem because they had FSA, they were IPP.
And they had a fuel supply agreement.
Yes, and they had a fuel supply agreement.
This problem today is about unit 1.
Yes, your lordships, absolutely. And my lords, before I proceed further, in a minute, let me also apprise, my lords.
Now, for unit 1, was there a fuel supply agreement?
No, my lords, it has not been given. It was denied. And it was denied on account of the fact that they had originally LOA as a CPP, not IPP. So that, and even that LOA expired, my lords. Within the time frame, they could not.
What is the nature of the dispute? Tell us what the nature of the dispute is.
The nature of the dispute is this, my lords. A very narrow controversy is this, my lords. They started supplying power to respondent number 2, their sister concern, on the basis of the projections that they have 100% domestic coal linkage, both for unit 1 and for unit 2. On that basis, provisional tariff was determined and final tariff was determined, my lords.
Yes.
Final tariff, my lords may note that final tariff was determined after the power supply started, 2 months after it. There was no application at that time that we don't have domestic coal, 100% domestic coal linkage. Therefore, we will have to incur additional money on procuring coal. Now, my lords, after the final tariff determination, my lords, when they filed the truing up petition, my lords, for determining ARR, my lords, at that stage, my lords, they say, though we could not get fuel supply agreement executed, yet we should be given the fuel cost on the basis of whatever we have spent by importing the coal and by procuring it from any other source. Now, my lords, we said that two things we said in the in our order, which was impugned before April. We said that
We'll just keep it next week.
My lord.
My lords, may I just make a submission in 12.2?
My lords,
I have instructions to
put it
withdraw.
my lords, after 18th, my lords.
Okay, we'll keep it up.
Up to 17th, I am not in town. That's why my difficulty.
Lords, may I just make a submission in 12.2?
Yes.
I have instructions to withdraw.
Well,
This is
12.1, we
87
allow
of
them to withdraw. Unconditionally, they want to withdraw 12.1.
12.2, Your Lordship.
Nothing to do with this.
12.1.
Your Lordship, 12.2. 12.2. 12.2, 87 of 2021. Axis Bank's appeal.
Are you pressing that appeal? Axis Bank's appeal?
No, I wish to withdraw it. Your Lordship, I have instructions to withdraw it.
We are also withdrawing. So we are left only with now.
Only with 12
Only could I request what I had mentioned earlier, my lord, that pendency will not, my lords, not prevent them from implementing this.
The moment you say that, he started arguing.
Yes.
Because there are proceedings coming on the 18th. My friend will repeat the same submission there.
Have you stated?
Very well.
What date?
Okay. Well, we filed accountable.
So we have filed a revised.
That item 18 about the CCI got to be
We'll take it up. All right, 18 we'll keep it up.
The friend is there on the other side.
18 we'll take up next week.
Today's that. Have some sympathy now.
Take it up.
No, they know.
Next week they want to take it next week.
Much of time.
Item 13, yes.
Yeah, my lord, we have filed. We have filed a revised written submission to 1124. Lordship may just keep that.
Now, what is
and
Dr.
Professor
Danda,
Danda is there.
what is it? What is the essence of the report which has been submitted by NALSA's disability wing?
That, my lord, Professor Danda wants to address.
Yes. Dr. Danda, what is the essence of your report?
The essence of the report is raising 2 points, sir. One is that it is talking about the fact that the government was obligated by the statute to be making rules and not guidelines. And what they have done is, under your Rule 15 of the RPD rules, they have formulated a range of guidelines, but they have not really made it rules. And it's not a nomenclature difficulty. It's not like they are calling something, guidelines which are in fact rules, because that seems to be one kind of proposition which is coming in from, in the written submissions of the government. My plea before your lordships is basically this, that it's a range, that there are various ways. I mean, the sense of way I understand rules in contradistinction to guidelines is that rules tell you exactly what you have to do. There is what should I say? There's a non-negotiable content in relation to what you need to be doing. Whereas what they have done, in fact, and I have three ways in which one would say, I can explain that what they have created is guidelines. One is like, I'll give you as one example. They have something like that you would have audio loops on every counter. Now, the connection, sir, you have to make is between the rules and your section 40 of the RPD Act. That is, if you don't follow the rules, the RPD Act's section 40 says that you can't, there's an obligation placed in section 40 for following the rules. And there is a sanction in section 44, which says if you don't follow the rules, you will not be allowed to commence building, you won't be given a completion certificate. You have your section 89 of the statute which puts out a whole range of fines and penalties. Now, for that to happen, for this connection between the statute and the rules, it's important that what they put down in the rules is a non-negotiable content. Whereas what they have done is it's all kinds of things, you know, to have an accessible toilet or to have an audio loop. Which of them is going to be, you see, it's like three kinds of things that they need to be putting there. So you have to be saying, what is it that I must have at the time when I establish something? What is it that must be part of the design when I'm establishing it? Maybe not immediately so. What is it that will need to come in progressively? All of those kinds of things needed to be put into the rules. You can't put everything there, leave it to people to take it or leave it. Our submission, I mean, what CDS is saying is that the rules that have been put together by the government are actually ultra-vires the statute. The statute required them to put together a mandatory package. What they have put in there is, you know, like they're saying, these are the kinds of things which would be desirable for accessibility to happen. If you just are going to operate on the desirable, then we don't know which particular rule, which particular guideline I follow or I don't follow will result in those consequences. If that kind of a connection between the rules and the statute cannot be established, then what we submit is that what the government has done is only created guidelines, and our work, the work that we have done across the country, is like we've got a range of organizations. We've tested out accessibility fulfillment across the country. We did not see our job as to come to tell the court that compliance is not happening. We thought that our job was to come and tell the court that why is it not happening? And what we have found, it's not happening because you haven't been able to put in place a minimum mandatory package. We can't sort of, you know, we can't talk in terms of accessibility requirements like we are in the United States. We are in India. We need to work from what the bottom line should be, and that bottom line needs to be unequivocally stated. That is not happening.
They have not framed that at all. They've only framed guidelines.
Yes, they've only framed guidelines. And it's happened with...
I don't think my understanding is correct.
Turn to my note, my lord. I think I'll solve this entire thing in 15 minutes. Just turn to my note, my lord.
Yes.
First, my lord, paragraph
So
1.
could I complete this proposition to you? But very swiftly, I just wanted to give you 3 examples there.
Professor.
One is that they're not distinguishing between what is mandatory and what is desirable. They try to putting the two together. The other is there's a range of technical errors which are coming in the guidelines. So if there are technical errors, then how do I know what am I supposed to fulfill? The third kind of problem that you have is that you have created some 80-odd standards. And such a simple thing as what is an accessible toilet is coming in differently depending upon whether your the standards have come in from the health ministry, have come from the port ministry, have come from rural development, have come from education. You've created an entire jungle of regulations, impossible to work out what is it that I'm supposed to. So that for us is a very, very core problem. And that's a problem only the court.
Tell your lordship. Yeah. Section 42-46 is couched in mandatory terms. These standards, whatever rules, etc., are mandatory. Even the Rule 15 is couched in mandatory terms, shall be followed. Correct. But while putting the title to the rule, they put guidelines, they put standards, and so on. Merely because you use guideline in a rule or standard in a rule, where the rule says it is mandatory and the section says it is mandatory, all that your lordship has to do is to say that the country will follow these rules and guidelines as mandatory. Kindly turn to the first paragraph.
That's what we are saying. Well, let's look at but that's what we're saying. I can read it out to you.
I think they agree to that as well.
Do you agree to that?
Yes.
They agreed to that.
I'll read it out.
So in that sense, we don't have a real problem.
I don't think I'm reading of the...
Choice, what are they guidelines or have you now framed a mandate?
Read out from what I've said in my written submission. And this is obviously vetted, and this is my written submission. These rules have been enacted in view of the statutory mandate envisaged in section 40 of the Act, page 4, paragraph 12.
Well, we have copies of my written submissions which I have submitted.
No, we got it.
Rule 15 provides for rules of accessibility of persons with disabilities. Rules for state that they shall comply to the following standards relating to physical environment, transport, information and communication technology. The standards for accessibility as under Rule 15 are not merely voluntary conditions, but they are rules which ought to be mandatorily complied by the government or private establishment. The same is consistent with the scheme and purpose of this Act. The language used in Rule 15 would indicate that the rules have been made mandatory and the same has to be maintained compulsorily.
So all that your lordship has to do is to stay.
Obviously,
So the government of India is also conceding that these have to be mandatory.
Yes.
They say in their written submission, Rule 15 provides for the rules of accessibility for persons with disabilities. Rules for accessibility states that the establishment shall comply with the following standards relating to physical environment, transport and information and communication technology. Standards for accessibility enumerated under Rule 15 are not merely voluntary conditions, but they are rules which ought to be mandatorily complied with.
Yes, because Manoj, the reason is because they are sectoral things. So we have to give some sort of standard justification, minimum threshold you'll have to meet. So it varies, and scientific and my lords will know that a rule takes a certain procedure to be followed. Standards can be set very specifically and changing of technology and things within that form. So
Dr. Chanda, Mr. Banerjee is conceding the fact that these are mandatory.
That's exactly my point. He's conceding to the fact that the problem is not a terminological problem. The problem is a substantive problem. You are also aware of the fact that just by their saying that something is mandatory, it is not going to become so. They are, it's not recognizing the fact that you're not taken the care to see what is it that will in fact become a reality. I'm sorry, sir, but it's just by saying that this is a rule or this is mandatory, it doesn't become mandatory. I mean, maybe because I'm an academic and I come from a more realist understanding of the law. I'm saying put down in the law which will in fact be carried. I'll just give you one small example, sir. Your type A toilet is the only kind of toilet which is truly accessible to all persons with disabilities. Whereas what you have across all the standards, which is coming from whether it is in relation to ports or health or hospitals or education, you have type B toilet. And type B toilet is called as a corner toilet. It's only something which is accessible to one kind of people with disabilities. There's a whole range of other things which don't happen. Because you have put it there and then you're saying this is mandatory, it's not going to achieve the objective of what the statute sent out to do. That's my reason for saying that just by their saying this shall happen. See, the chapeau or your 15.1 speaks in terms of these shall be but the actual, so we have done.
Rule 15 says shall comply.
Yes. No, I'm not denying that they are saying they shall comply. I'm just saying to you that you are us. I'm just giving you a second example. You talk in terms of an audio loop to be put on a counter. Now that audio loop is not going to synchronize with 75% or at least in fact as much as 90% of hearing aids that people have. You have not bothered to put in the rules that which will in fact be complied and become a reality. That's the point. I'm saying we were not asked to come to you and to tell you, oh, this is not happening. And we are not even trying to do that. You've seen our report. We have not done that. We are trying to say that there's a necessity to go back to the drawing board to say that which you put down that as mandatory or that as a rule, which is in fact going to be implemented. Not something which makes
right now?
Yes,
everything's been notified.
Large number of rules have been notified.
Each sub-rule has been notified, Malaj. Yes, Malaj.
Run you through the note. I think I'll finish it.
But tell us what your grievance now is. What directions do you require from the court, Mr.
Yes, sir. I'll tell you, Lordship, as far as the Act and the rules are concerned, for example, no building, new building, I'm talking about new buildings, no building was to be constructed until the accessibility clearance was given under the rules. Similarly, no completion certificate was to be given until the accessibility certificate. Not done right across the country. Taken as granted that you don't have to do it. So the moment your Lordship says, Section 45, read with Rule 15, and all the notifications issued under that are mandatory, it brings about a sea change in the country. New buildings can't start unless they get the clearance, and existing buildings have to be retrofitted and changed and so on to make them accessible. Now, I understand it's not a 100% thing, but we go a huge way forward. If your Lordships just say this much, that's the first part. Now, the second part, my Lord, and I've given it to you in my note, I won't read it out to you. In 2018, a bench of Justice Sikri actually took the Accessible India campaign targets, because otherwise everything was in the air. And there were targets given by the Union of India for buildings, for airports, for buses, for websites, and so on and so forth. So that order is at page 3 and carries on. I won't read it out to your Lordship. But that order forced the government to go at least halfway. If the target was to get all the airports done, then, my Lord, the Supreme Court order said in 2018, do half, or do half of the buildings and so on and so, buses and so on. So that's page 3, 4, 5, and 6.
All right.
So, my Lord, we want to take that to its completion, namely, whatever the Accessibility India campaign targets were.
They have to be complied with now.
Yes, my Lord. 2018, you gave them a chance. You went halfway. Now, Supreme Court will say you comply with those completely. Then, my Lord, the Supreme Court in 2019 again, there's a second order which says you give concrete, every state must have concrete, tangible numerical targets. So now if you're saying buildings, for example, in the state capitals, because that's a separate category, the states have to give concrete targets. 100 buildings, 150 buildings, 200 buildings, and so on. Then, my Lord, in the NALSA report, and it's really good work done, my Lord, is broken up into non-compliance under four or 5 headings. The courts is at page number 6, what is missing in the judicial system for accessibility. At page 7 is the prisons. Page 8 are the schools, showing, my Lord, a deplorable situation. So it highlights where.
Basically, we have to issue directions.
Yes, my Lord. It's straightforward. Yes. I'll only take 5 minutes more and leave it to your Lordships. At page 7 against employment and the employment portals and so on. Then, my Lord, at page 8 is the orders of the Chief Disability Commission and the state commissioners. Here, my Lord, the orders are being disobeyed all across the board. All that we are saying is, these are people appointed by the state governments. All that we are saying is, when your disability commissioner makes an order, you cannot ignore it. You implement or you challenge. But you cannot just turn your disability office into some kind of a completely. Then, my Lord, yes, Lord. Then, my Lord, from 10 onwards, is the direction sought, my Lord, how to do it. I don't have to go into that, how the buildings are. But, my Lord, there's one thing. The central and state disability advisory boards were to be set up and made functional.
It's set up?
They are, in some places, they are not functioning in others, but that, my Lord, we have given your Lordship those details. 1 second, please.
All right, let's hear Mr. Banerjee. So, now the brief. We'll see your submission before we declare an order. Mr. Banerjee?
Yes, Lord, that's the sum and substance basis.
We understood what
yes, Lord.
Randa also said.
We are happy to leave. And, my Lord, if you don't mind, before Mr. Banerjee begins, I'll give you the latest. They've been updated, the standards and guidelines.
Mr. Banerjee?
Yes, Minister.
Yes.
Well, it's according to us, well, it's as we file the affidavit, we have in an annexure what steps we have taken and what has been complied with. But 2 provisions I just want to bring to Lordship's notice is 45 and 46, which gives the time limit for making infrastructure and premises in government buildings. There's a time limit of 5 years for government buildings, for infrastructure. For other service providers, it is for 2 years. So they will have 2 years for the entire, and that 5 years is still not over. But my lords, we are getting it. My lords, what action we have taken, we've disclosed. We are trying to get everything compliant. But my lords, there is more importantly, my lords, I think what may fall to lordship's appreciation is I have an application where I said that you broad-base the committee so that to find out a roadmap. And if lordship would be inclined to formulate that, my lords, at page 9 of an IA, where I said it is most humbly submitted and prayed that a committee may be formed by Department of Empowerment to arrive at a roadmap for making built up. Well, that's what we suggested. So
have a look at yours.
And well, we've put in our.
Yes, given us your
Well, we've given a written note. We've already given a written note.
Get it by day after tomorrow. Yes.
Please, my lord. It'll go a long way, my lord, on accessibility.
We have also
go a long, very long way.
Thank you, Dr. Dhanda.
Thank you, sir. But I sort of would still again urge you. I know, I mean, it's not my everyday calling, but I would still again urge you that let us not just look at the terms that are being used. Let us also look at the substance of how these rules have been made, or these guidelines have not been formulated in a manner which can be called a rule. I would really worry, because I think it requires you to understand it's not the way in which it is called, it's what you're doing with it. The fact that there are a range of technical difficulties coming in any number of those guidelines, I have an entire table I could provide for. That the fact that even a uniformly accessible type A toilet is not being provided for in this 18 plus guidelines that they have created. We should not give the impression that we are doing well in places where we are not doing. It requires like looking at the whole disability question and the accessibility question in the face. That's my basic plea to you.
I can really
and that's where I'm not sort of I am not in any way trying to diminish the work which has come from the government. I'm only trying to say that one, we have conflated retrofitting with future work. We are only talking about the entire Accessibility India campaign, even the witness submission which has come in from the government, is only talking about retrofitting. It's not talking about the new work that you're doing.
My learned friend is
and
on,
in the
Manos, we come to Rule 15, where we sectoral specific, and I can take, it's a long list of every sector we have addressed. We've come out with rules of every sector.
That's what I gave
standards are to be achieved. Manos, I can read it out to you, Manos. And the culture sector specific harmonized accessibility, guidelines for accessible sports complex, standard for public buildings, Rule 15, Malas. And then for violation of these rules,
Portmaster, give the last.
And we obviously, because there may be some improvement, higher standards, so we include that.
See the last page of this, my lord. Page 3 in second last page.
Websites.
Yeah, here, left on the right hand side.
Civil aviation.
On the right hand side.
Guidelines notified in the rights.
Give me my
Rule 15. Rule 15.
Give me my copy.
Because it's called standards stroke guidelines.
Yes. And
correct, my lord.
Mandatory.
16.
We've said it's
yes, but where
the standard
in relation to an accessible toilet is not the same. It's different in every one of those guidelines. We are talking in terms of we are bringing in some sort of uniformity. We are not
one standard, say for toilets, accessible toilets. They don't have one.
At least that's a minimum. Type A toilets should be there as a mandatory requirement.
What my learned friend wants
that's a minimum.
Across the board, a standard for toilets across the board. I don't know whether that is, but for public buildings we have a standard. I'm sure, Malas, I can disclose those rules. We can also have accessibility to toilets and what to make for toilets.
No, sir. You have to. Your own standards are only allowing for type B.
Minimum standard everywhere.
Malas, but I think I'm sure that would have been put in.
No, it's not. You're mistakenly sure, sir. It's not the case. It is not.
Rural sector, harmonized accessibility for everything.
I'm sort of saying to you
community
that
toilets, my lords, will come to
no, it's all type B, sir. It's not type A.
J.
What is Dr. Dhanda saying?
I'm saying it is not type A, it is type B. And type B is a toilet where you can slide to only from one side. A type A is wherein whether you're coming in from the left or the right or the front, which is the kind of toilet you require for it to be an accessible toilet for all people with disabilities.
She may not.
And your standards are, I could actually present to the court that
So
how
what you
the
can do is
standards in
take it
relation
towards
to toilets are
the-
varying from standard to standard. My
But
learned
against the
friend has
broad
not looked
sweep
at
of
it.
change that you want, these 16 guidelines are for the ports, the banking sector, the police
Yes, and the
stations.
banking sector,
We'll
we
be
have not
very
even provided
happy to
for.
get this across.
Well, it's public
No, sir,
toilets.
that's
We've all mentioned
No.
that. That's J.
So it is to say ports, banking and health and education within
Ultimately,
every one of them.
You don't have a type A, for instance, you don't have a type A guideline for toilets at all.
Well, it's only
They have a type
So,
A
you know, it's
listing in
accessible only
relation
from
to
one
the
side.
national building codes.
I can verify that. Man, this is being said at there's a type.
But that's what the report.
Yes, Lord, we
No, there
have
is,
that.
no, what I'm
If you
saying
turn
is that
to
is
the last page, you'll see the latest harmonized guidelines 2021 include the guidelines for toilets. The
yes,
last
they
page.
do. Yes, they do. But they don't
Harmonized
say.
guidelines 21.
Right.
Your Lordship, can I have a word, please?
Yes, Dr. Ganga.
Yes, 2021, they have included, but they have not said that you necessarily need to have type A toilets everywhere. So what you have done in relation to the 18 odd standards which have been notified, that they are only going for type B toilet, which is a smaller toilet, which is a corner toilet, which is not accessible to everyone. And then you are saying that is going to be the rule, and that's going to ensure accessibility to everybody.
Yes, sir.
GG.
That's a one-page note.
Yes.
What are the possible, areas that we need to look at?
I put it into my note,
Your submission.
but I'll do a one-page note, my lord. And then
Give it to the court master.
I'll do that.
How quickly can you give it? Because I'd like to sit down and dictate it all.
Your lordship wanted by tomorrow morning?
Can you?
Yes, of course, my lord. I'm very grateful that your lordship is taking the
Email
Your
it to
Lordship,
me
can I
at
have-
9, so then I can dictate it.
in the night. Yes, lord. And I'll talk to Professor Danda and see what
Dr. Danda, if you can,
Yes, we could submit to you exactly what we are seeking.
So then if I get it in the night, I can dictate it.
I'll do that.
Yes, sir. So we definitely, we've done all the homework for it. We're sort of saying to you that at least as a basic minimum, which needs to be provided for everywhere.
But my
And
note
it's a jurisprudential distinction I'm making between rules and guidelines. And I don't think it is important to just talk
Absolutely
about
valid,
it in
Dr.
mandatory
Danda.
terms.
That's a basic point. We've already understood that point. We are looking beyond that.
Yeah, that's exactly.
These are
See,
guidelines and
sir,
not
in
rules. It's a valid point.
in our report, the last part of our report has also sort of said we are asking for the government to sit down and go back to the drawing board and really say what is it that they're insisting will be done immediately and now. It is important to be
Timelines
saying that,
of
sir,
what
because
can
I
be
am aware
achievable
of
in
the
the
fact.
short term, the medium term, and then the
Yes, sir, absolutely. That's exactly what we're saying. Because the moment they in fact started imposing fines, they in fact start shutting down places, everybody will be right here.
But that
The timelines were there, so they got 6 years.
Gives us some leeway for people to comply.
All right. So
Because
this
your 5 years have
copy by
already
the night,
over. If they are saying,
Yes.
so that he knows what you have given us.
Yes.
see,
Mr.
your lordship, if they are saying what they,
For tomorrow morning.
Tomorrow morning, madam.
Tomorrow morning, first we'll take it up on board.
Lord,
Because only there's some event in the evening which I have to attend for the staff.
yeah,
So
only one request, my
we
lord.
could have continued.
Item 19,
Yes.
my lord, it is that coastal road, my lord.
Mr.
Lord,
CU
I am ready to say the Mr. CU Singh wanted that we should invite tenders. We'll invite tenders, my lord. I have no difficulty, my lord. What else, my lord? I'm posing a question to myself, my lord. An environmentalist is objecting to, Lord, plantation of some small plants.
But then is he agreeable to that? And they were going to do it free of charge for you, you said.
Yes, my lord. Now we will have to, my lord, take money. My lord, tendering means whoever pays more get the work.
Will get the revenue.
I'll get the revenue.
But then what are you going to rely on your on that 11th of October 2024 policy that you referred to yesterday, or will you
What, Lord, according to me, both the policies permit me to have, my lord, this kind of an arrangement for free.
Mr. Sikh, here right now, we'll keep it tomorrow.
Item 15 to 17.
Can it be tomorrow, my lord?
Unless it's
Item
necessary
15 to
tomorrow,
17,
then your
my lord,
lordships
just
can
keep
have
it
it
on board.
next week or something unless it's necessary tomorrow.
Whatever, I mean, all
Then let's have it next week or the following week.
One thing, but with regard to the trial begins on 11th. Now, they are saying there's a larger conspiracy. So Maraths will kindly stay the trial again, otherwise it will go for a retrial. Because if Sanjay is the main accused, Marath, they cannot, if there's a conspiracy, then the charge has to be reframed, which has already been framed.
Well, because
Where is the CBI?
On your right.
You are all in one.
I mean, up to your lordships, my request only is that.
Let's hear it tomorrow. You can let us see the status report tomorrow, what they have by way of the latest investigation. Take it for about half an hour tomorrow, and then we'll see. Then we
Very
can
well,
push.
very
My lords, if it
Can
could be
it-
heard at speed, because there are some final directions.
Subject to your lordships, my lord, other commitments.
I'm
Can
given
it
to
be at
understand charges have been framed already. my lord.
Yes,
Charges
charges
have
were
been
framed.
framed.
Yes.
We'll take it up at 2 o'clock tomorrow.
Yes,
2 o'clock. I'm sorry.
You said 2 o'clock?
Yes.
2 o'clock. my lord.
No, so that we can do the rest of the board in the
You're
morning.
in a partner matter, no?
Sorry, the
That's
next.
why I'm.
Then how will it be at 2 o'clock?
Sorry, what?
You're in a partnered matter against me.
I.
Then, so then how can it be at 2 o'clock? My learned friend took time because he was in this matter. Now it's the same thing tomorrow.
Sorry, sir. Well, 14 to 17 are those Rajasthan disability matters. Lordship will just take it for 10 minutes tomorrow because all submissions are now there.
Yes,
Mr. Farasat
have been filed for the judicial
Yes,
service.
but everything is there, because we just need one line order.
Just 2 o'clock.
Sadar, let it be tomorrow.
Yes, we accommodate you at 10:30 if you both want.
Yes.
My lord, kindly have it at tomorrow, at 2 o'clock. My lord, that I would
The
request.
officials are here for the last several days. Can we let them go? Let it be 10:30. We were waiting with us all this while.
No, but 10:30 and 2, what
So
difference?
it makes a difference to you as well as me.
All right, you both decide and tell the court.
14 to 17. please have it.
No, lord,
My lords may decide. We are the many of us in this matter. Either 10:30 or 2, whatever is convenient. Very well.
To 17.
Plus 14 to 70, let it be on board, the disability matters.
Officers come at a-
Grateful to your lordship.
Not taken up again.